Hey, let me know if you guys can hear me. Hey, Danny. Hey, Simply Solo. Hey, Felisa. Elser. LR. Yeah, there was no way. There was no way. It's probably going to go a little bit late. I'm prepared. I have coffee. I have water. I'm good to go. We're going to go through this whole thing. I have a notepad so I can take more notes because today was wild. Hey, Kelly. Hey, Claire Bear. Hey, got something to say. Yeah, it was insane. I got up, I did some laundry, I cooked dinner, did a bunch of other stuff. Right now, what we're going to do is actually go through it from the source. They have not removed this. This is the first one that they have not immediately removed from the YouTube page. Now, I did go in and I recorded everything that was public, and it just now finished downloading. I have that in case they go ahead and get rid of this. And I will probably go ahead and upload that one also at some point so that you guys have like a no comments, no pop-ups, no any of that stuff. It's just straight up the hearing with no interruptions. So I have that, but I'm not going to play today's like review from that. We're going to do it from the YouTube channel. I am trying to understand it myself. It's very much insane. Hey, Summer. Hey, Sarah. Hey, Carly. Yeah, I am just like, I'm bewildered by the things that I heard today. Let's just recap. Let me see what I can remember so far that has like not fried itself from my brain. Let's see. Instead of 3 unknown male DNA, we now have 4. There was blood on the handrail of the stairs in which Dylan apparently heard somebody running up and down. And the bathroom is apparently being referenced in the PCA because that's where Dylan heard the crying coming from, the bathroom. There's just so much here. And like I've been saying for a while, like as many questions as I have for Dylan and Bethany, especially Dylan, I have been saying the whole time that we haven't actually heard from them. Even at the memorial service, we apparently were being read letters that they wrote, but we don't really know if they wrote those either, honestly. And that was pretty much verified. If what Ann Taylor said is true, that the information that she has from interviews, cameras of listening to the transcripts of the interviews and the way that Dylan said it in her own words, the way that it's being interpreted to us is wrong. Welcome, Layla. I think you've been a member before. I don't know why it doesn't tell me that. Like whenever it's like a renewal thing, I don't know why it doesn't do that, but welcome. I'm just like, I don't even know. What I don't understand is like these unknown male DNAs, like, have they even been compared to Bryan's DNA now that they do have like buccal swabs of him? Because that's what I've questioned about the Delphi situation too, because in Delphi, I don't know which girl has which one of these DNA sources on them, but one of the girls has an unknown male DNA underneath her fingernails, and the other one has a male liquid on her thigh, and they're both like unknown. Could be 2 people, could be the same person. Have they even been compared to Richard Allen? No. It's just very insane that we have all this time and it's gone from 3 to 4. Blood on the handrail of the stairs where Dylan heard somebody running up and down. Like, I am just bewildered. But we're going to go through this again, and I'm going to do it at 1.25. If you've been here for a while, you already know that I talk really, really quick. So I feel like if you guys have been here, because you can still understand me even whenever I'm like going off in my rants, I feel like 1.25 will be okay. Well, we're going to try it out and see. But they just talk way too slow for me. Way too slow. You can tell on Judge Hippler's face that it was too slow for him too, but he was trying. Now, at first he was really disappointing me because I feel like he was being so rude. But then he was still so rude, but he was so rude to both sides. So I'm actually really glad that he's making both of the sides like work for it, because Judge wasn't even trying. Like, he wasn't trying at all. It was really bad. And see, and this right here, how these girls were supposedly home and did not call emergency is unbelievable. That's been my thing for so long, because there's no way. We went from there actually being more evidence of the truth in the beginning, before the PCA, before the gag order, because we heard that Dylan opened the door several times. We knew that. We knew Dylan heard stuff. We heard that from the very beginning. We also knew that she yelled, "Shut the F up," upstairs. We know that she heard things. So whenever they came back to us and they're like, "Oh, well, she didn't hear or see nothing," bullcrap, because then the PCA says what we heard about in the original rumors. And the stuff about Murphy, that whenever the cops got there, I'm guessing this is what I was asking about, the body cams from what are their names? Smith and Nunez. That's probably, I'm probably saying that wrong, but they're in the PCA. I wanted to know what the body cams looked like of how the house looked before 4 hours later. You know what I mean? Whenever the walkthroughs from Payne and Blaker happened or whatever. I wanted first responder cameras. So I'm going to assume that first responder cameras shows that all the doors were closed except for Kaylee's that was wide open, and Murphy was in it with no blood or anything on him. We know that they tested him for DNA. Okay. There was nothing on him. Nothing. And that still proves that there was nothing in between the crime scenes, because with that door wide open and now them saying that he was barking for like 25 or 30 minutes straight, not just like, oh, barking at 4:17 and then it's gone. No, he was barking for 25 to 30 minutes even after the car done left. And the car, holy crap, the car that they are trying to claim is suspect vehicle number 1, that's got to be Bryan's, is literally only seen on one camera and one camera only. One camera, bro. One camera. I am just bewildered at what we heard today. But I know that I missed some stuff. And we need all of it. So, we're about to get this started. How long have we been live, does it say? 6 minutes, 37 seconds. Okay. I'm about to pull this up here. And like I said, I am going to be playing this. Oh, no, I got to remember which one it was. I haven't used this thing in so long. I am going to be playing this from the source because it is still on the YouTube page. So that's where we're going to be watching this. But I do have it recorded and put together and downloaded. And I believe altogether, let me see so I can tell you. Is it going to tell me? 1 hour, 38 minutes is the public portion without the, what, bro, 5 hours and 28 minutes is what I had to take away from all of the silence, this is closed, blah, 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 boo-boo that we got today. 5 hours and 28 minutes. Such a long time to just sit in silence, but we were talking about food and all kind of stuff, so it was fine. But this is where we're going to start it. So I hope you guys are ready. 1.5. Like, we're going to start it at 1.25 and we're going to see. All right, let me know if you guys can hear everything okay. It's going to start up in here in just a second.
We can.
Eek. Okay.
You know when we're ready, Sandra. All right. We are back on the record.
And I'm going to be looking at the chat while we're like looking at that and I'm listening. So if in case I don't see it, like if you can put just like something, I don't even know what kind of emoji. I don't know, some sort of emoji so I don't miss your questions. I don't like doing paid questions. That actually kind of bothers me. A lot of people don't answer questions on their channels unless somebody like pays to ask a question. I think that is crap. I just don't want to miss any questions, but I also don't want to not go back on something if y'all need me to like go back on something. So just, I'm going to try to pay attention to the chat as much as possible, but remember that I'm also like, I'm taking notes too. So hello, everyone who was here for all this crazy stuff earlier and is here for all this crazy stuff again, because today was crazy. We starting right now.
Date be Kohberger CR0124316665. We are now, I believe, streaming. For the record, the defendant is present together with counsel, Ms. Taylor and Ms. Massoth. The state is.
And y'all, look, Eliza Massoth, I don't know what kind of like happy pills she's on, but this grin for the whole 8 and something hours that this played, 8 hours and 3 minutes that this played through. I know that for the whole 1 hour and 38 minutes that we saw her face, she's got a grin from like ear to ear the whole time, just a smirky grin. So I bet you if she held it all the way to the end for us to see the whole time, it was like stronger and more prominent earlier in the day, but she's just got this grin on her face the whole time. I think it's funny.
Present and represented by Mr. Thompson. Mr.
Maybe. Can't say that on YouTube.
We are now going to hear argument from the parties on the Frank's motions filed by defense that will include the Frank's hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Frank's issues as to why the court should hold a hearing on those matters. We're holding an evidentiary hearing on those matters. Am I missing something we talked about?
This is the first thing I noticed. This is the first thing I noticed. He looks thinner. And like, I know somebody said that it looks like his chair is sort of lower down, and that might have a lot to do with it too, because it does look like it's lower than the lawyer next to him. But his neck and everything, like he looks kind of, what is the word, gaunt? He looks like he's lost a lot of weight, and it's been a minute. Like for a while, whenever he first got in there, he was actually looking healthier for a while, because I mean he's a pretty big guy. I'm seeing y'all are saying that Payne is sending messages on his phone. I guess we about to find out.
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well, the suppression IGG, we can also argue that. I think it's wrapped up in the same issue.
Is it not loud? See, I have like a copy of it. If it's not loud, because I can't fix their volume, as far as I can tell. Like it's up. Let me check this setting. Like I'm pretty sure it's as loud as I can get it to go. Let me see if the volume on the copy that I have is better, then we'll just play it from there, because I want y'all to be able to hear. Give me a second. Let me see what this sounds like. I mean, they do. Okay, hold on a second. Okay, to me it sounds the same. To me it sounds the same. Yeah, and I've already turned down the microphone, and I'm actually, like, my microphone is off camera. Like, I'm not talking out of this. I'm talking out of my USB mic over here. Let me see. Yeah, and it's turned down because I'm not talking out of my headset. Maybe I don't know. Let's see. I don't know if it's gonna let me do that. Oh no. Okay, we're just gonna have to play it from here. It should be okay.
I thought we were going to Frank's next.
I did not. I apologize.
No preference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Frank's items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Go ahead.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by 4th Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Moscow Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pool in Pennsylvania, and there was no warrant for that trash pool either. All 3 of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake.
He gets on my nerves the whole time he's talking to her about this, because he gets really like just, I was making comments about his lips, because it's like every single time he says something that he thinks he's like really attacking her with a point, he makes this like pursed lip face. It's kind of annoying.
The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search.
It led nowhere. So see, I guess we had who it was incorrect, because remember, we had originally heard that ISP couldn't find anything when it came to finding a profile or finding any DNA on the knife sheath, but maybe it was Othram that actually couldn't find any matches to the profile that they did create. I mean, I guess it could be both. I don't know. But I know that the rumor about ISP not finding any DNA was just a rumor. It was never really anything that I could find that the cops actually said. It was just like in a magazine or some crap, or maybe it was even Bloom, who knows. But it was something that was never verified. So then they sent it off to Othram, and that's why I was questioning why they kept stating that it was a state entity that found the profile, because according to everything we heard, Othram was told, you're done with what you're doing. The feds came and took over. That makes it federal country, not state. So Othram, who has been solving cold cases, again, that go back to 75 plus years when people's, photos were in black and white, they're serving stuff. They're solving things like that with the technology that they have, and they found nothing. They found no connections. So all of a sudden, and this is what they're going to claim, the profile that they created at Othram from what they did have from the knife sheath is then doubled in size, because all it is a data sequence. All it is a data sequence. And just like we learned whenever all of the IGG experts, which by the way, some people didn't realize this, and honestly, I'm not really quite sure which one is which, but I know for a fact that the two women sitting behind the defense, one of them is Bicca Barlow, and the other one is, I believe her first name is Lisa, but her last name is Larkin. They were 2 out of 3, because the other one was Vargas, the one who had the feds come knocking after she told us about all those loopholes. These are the other 2 DNA experts that the defense has already had speak on their behalf. So, and then of course, Payne is Mr. Clean over here in the back, and Mowry is over here on this in front of Payne. But I don't really know. I don't know who the rest of these people are. I don't know who they are.
And from there, they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist.
Y'all are probably right. There's a few of you saying that it might be Payne and Mowry's lawyers. That's possible. Now, see, this bothers me, because why would Othram's information just be non-existent? Why would it just be non-existent, completely just not there? If they didn't find a result, if they were unable to find a match for it, there would still be a paper trail. There would still be stuff that Othram would have, but they're being told that nothing even exists. So there's nothing from the Fed work that actually pointed to Bryan, and there's nothing from Othram that didn't point to Bryan. So the stuff that is exculpatory to him, and the stuff that they are claiming does put him as the actual suspect. Both ways. Both ways, there's nothing. It's the same thing with the camera thing. There's no cameras going one way showing anything, so it has to be the other way. Even though there's no cameras that way either, we're just going to assume that that's the case here. It's interesting.
We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week, not through the motion to compel process.
There's a lot of it because of it is proprietary, thus they contract non-disclosure. Well, no, not for the investigation, not for it to be put in there as evidence. I don't think that would have anything to do with anything. I think that if it has something to do with the case and it has to do with it being evidence, then that wouldn't have anything to do with it. I don't think that'd have anything to do with it. I don't know why my lights are doing that. Is it because I'm moving? Is it just going to keep doing that? Ooh, that's going to annoy me. Why is it doing that? Is it because of my shirt? I don't know why it's doing that. All right, let me turn the camera off and play this.
This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the JED doc.
Okay, so let's talk about that. In the beginning, there were rumors. A neighbor told mainstream media that apparently Kohberger did some sort of ancestry test. I don't remember if the name of the company came out. I don't think that they gave the name of the company because maybe it wasn't even said to the neighbor. I don't know. But I found that if that was true, then I feel like the defense would have brought that out at this point. And I didn't even realize that until now. They've never came out and verified that rumor about him taking an ancestry test. So I don't know. I find it strange.
.com file. I don't have.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger's DNA was on the knife.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. Those databases don't churn out a name and say this
I
is
have
your
a privacy
suspect.
interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor.
Okay, is it still loud? Because my microphone is 1,000 meters away from my face, and I have it down on volume 12. So I don't know why it's acting crazy. I can try to switch it to this one and see if it's loud. Let me see. But you notice how he's being a super smart ass. He knows that's not at all what she's trying to say. That he should be able, you should be able to stop somebody from doing some sort of ancestry test. He's just being a complete smart ass at this point for no reason.
Is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA. It,
But not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
that's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position,
I agree that part was is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in violation of his rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here, he went to this crime scene, committed these murders and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law. And I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is.
I have felt like they have been really, really trying to get the most, like the majority of the work done by the defense, because the defense is the one coming out here like really questioning stuff, and it's showing how ridiculously incompetent and lazy the state was, because they literally did nothing to get anything put together, to organize anything, to make anything make sense, to make sure that what they were actually having put into evidence was actually something related to the case. It's all a bunch of just random stuff just thrown all in there. Insane.
Different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different search.
So I'm going now to, I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
But see, it's different. It's different. Because if they feel like they have to have a warrant in order for them to go and get the USB from Bryan's cell phone, that the feds actually did the forensic download and put it on the USB, okay? If they have to get a warrant to go and get that from their own lab, then why wouldn't they have to get a warrant for this? Like, I find the fact they have to get a warrant for their own lab absolutely crazy to me, because it's your own, like, you're asking yourself for permission to get something. I find that odd. But for this, it makes sense to me that you would need a warrant. It really does. For this part, I agree that, yeah, it needed a warrant.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I think one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about.
Okay.
Our first point is it was an illegal search. And this is if
The
the
search, which
court's
search?
assumption,
Which search? It was illegal.
well, first the snip at Othram, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA testing of the material left allegedly on the knife sheet.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret.
No. Not, I mean, not according to the dates that we have, I don't think. Did Danny's asking if they had his DNA before the traffic stops? No, those I believe were on the 15th. And I think they said that they had the name on the 19th. Because there was something that happened at CVS on the 16th that I found strange. But even that was still like the day after the traffic stops. So no, the traffic stops were definitely like 4 days before they had his name from the IGG, I believe.
Secret that happen when there's a portion of the DNA taken and it's searched by Othram to create a SNP. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the SNP ourselves. That's what I'm talking about. Those are the problems. As far as asserting family,
Specific DNA tests done of the sample that goes from legitimate to illegitimate.
yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath,
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose. And I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was,
This is a good point. This is a really good point. There's lots of stops. Because you're right. You have the one in October that they actually are letting us look at. Then they have the one from August that they refuse to let us look at. And in case there's some of you in here that don't know this, I tried to file a FOIA for this again very recently just to see what they would do with it. The traffic stop in the PCA, the August one, and they still won't let us have it. And I don't see why if he was by himself and it was like more like off the highway by like where a bunch of shopping and stuff was. Like it had nothing to even do with King Road. Oh, thank you, Chief. Thank you. I appreciate it. Thank you for being here. He's a bad driver. I mean, maybe, but I don't know. I just find it crazy because that's a lot, especially getting back to back on the 15th. That's absolutely wild. I cannot stand how this thing does not work. Okay, there it goes. And yeah, if for those of you who don't know, where are you at, Willie? Right here. This is Willie. Willie actually went to school with Bryan. Like he knows Bryan from back whenever they were in school. He's a few years older than Bryan, but he also knew Bryan's mom and dad from whenever I believe they worked at the school, or at least Bryan's mom worked at the school, right, Willie? But he personally knows Willie, and Willie has been in this community for a while, not really trying to like push any sort of narrative when it comes to Bryan. He's really just trying to get the fact stuff, but he's very much under the assumption that this is like one of the most corrupt cases, one of the most corrupt cases ever. But in case you guys didn't know, this is Willie, and he does know Bryan personally, just in case you guys didn't know that.
blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
site to that.
I'm sorry.
Can you give me the site to the Davis case?
Can. 2 seconds. 2 seconds and glasses.
apologize because my memory tends to be fact-based and not name-based, and so that's
muted. Okay. Harsh One Shelley said, I feel they may have manufactured the DNA match for BK as a fall guy. I don't know why, but it's not adding up in my opinion. Richard Allen, for example, different methods of getting the guilty appearance to public. I mean, I don't disagree with that. I feel like this is literally like Delphi 2.0. There's nothing. And you're gonna hear, like Anne even says later on. Now again, it is the defense claiming it, but Anne straight up says the state is claiming that this DNA is the single piece of evidence that links Bryan to this. And they also hunker down again on the fact that there was no connections in anything in the social media. Like, this might as well have been the trial, and Bryan should have been free to go the second that this was over. Like, legit, this was insane today.
my liability.
Well, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. I can't remember what page. It is
I wonder what Bryan is thinking in these couple of moments whenever Anne is like shuffling through paperwork and putting her glasses on. I know it's hard to see, but if you like look closely, he's like kind of like looking around and he's kind of just like, I think it's kind of like, it's interesting to watch his facial expressions because you can tell that he's paying attention to everything happening. He really does not like Jennings. Watch how he looks at her.
690 F3rd 226. All right. And so those are the three areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI.
Do you know how many like possibilities of matches that opens up to? And again, if Othram, the like for real experts that again have been solving cold cases that go back to the black and white photo days because of how they do all of this stuff. How are the real for real experts with a more simplified profile, with a more specific profile, okay? With a very more narrowed down specific profile, not find anything. But we're supposed to believe that they've got it right with the profile twice as big, meaning it could literally go to like however many people, like however many possible matches. I'm just so floored that they're just okay with the fact that everything from Othram, from the feds, and everything when it came to how anything got done at all is just non-existent. How this isn't automatically grounds for something, I don't understand. How you have to sit here and like beg for the judge to understand something that's common sense. I really just don't get it. I talked about it a little bit today, SD, in the earlier one where we had 1,000 years to talk about food and all kind of other things. I mentioned a little bit about how I felt. I mean, look, I'll tell y'all, I guess I'll just tell y'all now real quick. I'm going to do a video. I am, so it's short and sweet. But everything about the 4chan post, the timing, the way that they would leave their phones and let it play on auto, the time that it took to get there, to do the crime, to get back, the 13 minutes that they now told us in court, the fact that the car that they are claiming is suspect vehicle number 1 is only on one camera, and I've always thought the car was crap and didn't really have anything to do with anything. There was like in the 4chan post, they were talking about how they would use like electrician gloves, and if you go back to the glove that Chris McDonough found outside of the trash can that they found blood on, I believe it is one and the same. I could be wrong, but I believe it is one and the same. It looks like the electrician gloves that you find on Google whenever I went to go and try to find like the comparisons. And the fact that they switched the timeline around and everything seems so reversed engineered, the way that this this off-campus house got completely demolished, the way that a certain family has been behaving and acting like they're totally okay and letting their kids go back to school and letting the house be demolished and not caring. There's too much going on here. This was an off-campus event. What the hell is a school taken over for if they weren't protecting something? It looks like it wouldn't be anything to do with the school because it was all off campus, but then what if it wasn't and it really was an on-campus situation because of the people actually involved and it doesn't have anything to do with where the house was? There's nothing here. There's no connection to social media. The phone is showing that he's not there. It doesn't make any sense. It makes no sense. None. That's the only thing that makes sense. There's more evidence that leads to that than leads to Bryan. Like straight up, it's like the only thing that has anything factual, because everything else is just rumor. There's no proof of any of the cartel stuff or any of the vitamin things or the rugs or whatever freaking YouTube's word we got to use for it. There really isn't. There's more. I mean, there could be. There definitely could be an angle when it comes to what would have caused the anger that would have caused this sort of attack. Okay, very possible that it could be something involved in that. But when it comes to things that actually make sense here, tell me what else makes more actual sense that we have proof of. I mean, the school literally taking over, Scott Green being everywhere, the house being completely taken apart, the fact that there's like no answers at all, hardly whatsoever, when it comes to what really happened that night with Xana and Ethan. Why all the secrecy around that timeline? But we got Kaylee and Jack and Maddie just thrown in our faces 24/7. Like, I really have thought that the Goncalveses are just a distraction that they're allowing because it stops us from really looking where we're supposed to be looking because we're too busy looking over here. That's what the government does. Why wouldn't the cops? They do it all the time. I don't trust none of this. But that part, I haven't been able to let any of that go. I really just have not. But I'm waiting for them to give me one thing that comes to Bryan. I mean, I'm not against them possibly having it, but I'm at like 0.5%. Everything else, they've proven nothing. I'm just not stupid enough to act like I know the answers to something that I don't. So I always leave that little bit of possibility. But he would have to be super ninja'd and super stupid at the exact same time. It just doesn't make any sense.
I went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Suppressed for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17.
I mean, it's both of them. It's both of them. It's not just the one roommate that's scared to come back. It's both of them. And that's been another thing that's always bothered me. Like, if they really felt like this was the truth, what you scared for? What you scared for? If you really thought that Bryan was the dude and you didn't have some sort of gut feeling that it was wrong, what you scared for? No, I don't believe nothing. I don't believe nothing. But honestly, again, this is something that you have to consider because of what I just said. I can't be a hypocrite. Okay, I can't. I cannot be a hypocrite. I have to say it for this too. I cannot say they have been giving us no information on Ethan and Xana, and all this stuff makes me think this, that, and the third because of this, and that's why Kaylee and all that's been thrown in our face. What if it's the same for Dylan and Bethany? And maybe they're trying to put it all on Dylan, when in reality, maybe it's Bethany's recollection of things that we should be questioning. You just never know really what they're doing. But I promise you, they love the fact that we are doing what we're doing. They use this as a distraction for stuff, I'm telling you. There's just so much. There's so much.
Of the Idaho Constitution. The purpose of offering that information is because there's a policy. So there's there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IGG databases that changed their rules in terms of use. after a different case used IGG to solve it because people don't expect to have their DNA
That was the point
searched.
of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
It's got to be a standing.
Your Honor, we're here because the state.
See, I feel like that's where she should have said, but he did. Like, if he would have, the way that we heard, like, the rumors that he took an ancestry test, I think that maybe this would have been where she would have said, but he is a customer and he did put his DNA out there. And that's why we're being like, bro, how'd you get it? Because he opted out. I think if that was really for real, just that clear cut, I don't see why they wouldn't put it in here unless they're for some reason saving that till trial to talk about publicly. But there is no way that the state wouldn't know if that was the case. I just don't know. Moonvale. Thank you. Yes, just the truth and the justice that is needed, not some bullshit. And that's another thing. The Goncalveses have been so adamant about making sure that timelines are not close enough, making sure that they're exact as they should be. Okay. Are they going to now demand, after all the crap that we heard today and how there's like 7 minutes of time wrong here and 2 minutes of time wrong there and everything else, are we going to now hear the Goncalveses be like, nah, fix this damn timeline and fix it now? Because they should be the ones having this argument. They should be the ones throwing a fit. The families, hearing how messed up the timeline is, why are they not demanding that they correct it? This is insane.
Has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that.
There it is. Hey, Julia, the one I share my name with. Hey, girl. Thank you. I appreciate it. Hey, Wes. Long time no see, buddy. 2 minutes is important. 2 minutes is hella important. And if they were not okay with the girls' timeline getting home at 1:45, whatever it was, that was false, and they wanted it exact, they should want this exact. Especially if it proves that the case is going the wrong direction and that the people who really did this are out walking around laughing at the fact this is happening. So Steve better say something. That's all I got to say. And I will show you guys the Facebook page at the end of the night. But I know that whenever I checked it before I started this, the Goncalveses Facebook page, there was a picture that they put of her like in the hotel room on like 2 phones or whatever from, I guess, last night. And then just like a we'll keep fighting for justice. Justice is coming type post with no details about how disappointed they should be and how disgustingly full of holes this investigation is. I just don't understand how they are not fighting for this to be more truthful.
That there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years.
He made a statement to Daniel. I'll pass.
Facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law. That's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle.
I know this has nothing to do with the case, but my 6-year-old just ran in here to tell me that if you wear a certain type of glove whenever you go to Gordon Ramsay's restaurants, they'll treat you better as a customer. I don't know what he's watching in there, but he is obsessed with Gordon Ramsay. And every time he gets a new fact about Gordon Ramsay, he comes in here and tells me about it. I just wanted to share because it's just funny.
With, well, I struggle to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how
That man is a judge. That man is a judge. He just said that. He just said that. If you're innocent and your DNA is carried to a crime scene by somebody who's not you because it got carried there, you didn't go to a crime scene and drop your DNA at the crime scene. Why are you even? This man gets on my nerves. Like, for real, gets on my
something
nerves.
gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here. And that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you
Fingerprints
went.
everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like
I mean, yeah. I mean, you do leave fingerprints on things that you touch for the most part, but you definitely will leave DNA in a higher ratio than you do fingerprints because it falls off of you. Like, somebody walks next to you and it's a little bit windy, here comes like dead skin cells and stuff onto the next person that you're walking next to. So it's definitely more prevalent with DNA, especially something like touch.
your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you go. You drive your car to go to the doctor. Your cell phone's hitting on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left if that's going to be the standard. You put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And
Exactly. And that's what we've learned, like, from the beginning, that there was literally nothing going when it comes to Bryan until they had his name from genealogy. They were surveilling other people down to the point to where they were grabbing cigarette butts from whoever they were watching in order to test for DNA. And it wasn't Bryan. It wasn't Bryan. So who was it? I would love to know. Who are you watching? And why did you stop watching them just because you got this name? Why did you stop testing DNA and finding out who these DNA samples were for just because you got a name from a sheath? You had blood on a stair rail, a handrail on a stairs. That's something that's connected to the house. That can't be carried in. Why wasn't that top priority over a knife sheath? It's just insane. Thank you, Layla. That's very sweet. Thank you. I can't see if it got like a little character on it from StreamYard, which I don't know why they haven't fixed that integration issue yet, but thank you very much.
It's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we are learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to
I was muted. Okay, this is a good point. I'm just going to try to repeat what I just said. Yeah, Chief is right. Why didn't they make family trees out of the unknown DNA? For those of you who were not here and didn't watch this today, this is going to be a spoiler alert, but for those of you who were here, you already know this. It went from 3 unknown male DNA to now 4 because an unknown male D is brought up, and that is the 4th letter of the freaking alphabet. Okay, that means it's now 4 instead of 3. So there's been another one that's apparently been accumulated in this since then. Why is it still that way? Why do we still have so many? Why are the investigations not continuing? Why have they not continued on blood testing things ever since this started? This is the same issue we have with Delphi. They had the freaking hair forever and they never tested it. They even had the DNA of the person who they believed that it was, and they still didn't even test the freaking hair in one of the girls' hands until the trial started. And again, there's unknown male DNA underneath one of the girls' fingernails in the Delphi case, and there is male liquid on one of their thighs that was not tested, not even against their suspect. That man's been convicted and is spending 130 years in prison for something that the majority of the world does not think that he did because the state failed to prove it. Like this, am I dreaming? Let me pull a Dylan. Am I dreaming? I don't know if this is real. No shit. What is even happening? How is this reality? This is insane.
raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Thank you, Your Honor.
Or should I permit evidence obtained potentially by searching?
And I'll say this before I let him talk for a little bit. Both sides want the IGG gone. So I don't know if in the end it's going to actually be taken out or not, because at the end of the day, I believe it's the judge's decision regardless. Because if the state actually files a motion of limine to have it removed, like they've been threatening to do the entire time but still haven't done it, then the judge, I think, can deny that and say, no, you're going to have it in court. I think, don't quote me, I'm not a freaking lawyer, but I think that's how I've understood it, that the judge can deny the motion and say, no, I'm not going to let it be taken out of here. We're going to keep it in a trial. Same thing when it comes to the motion to suppress. As you can see, it's up to the judge. But regardless, both sides want it gone. But here's my question. I don't think I've seen a motion of limine yet. Have we seen that? I don't think so from the state. So if the motion to suppress IGG gets denied when the defense wants it, do you think the state's going to go ahead and file their motion of limine? I don't know. But I know that they've been wanting to get rid of it since the beginning. It's so sketchy. Beyond sketchy.
Databases that by its own policies, law enforcement said they wouldn't search.
So a couple points on that.
Did he just say that law enforcement's policies say that they don't search the places that they've now admitted to searching? Let me see if I can get that back in the right spot.
So a couple points on that. First,
Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about.
Or should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
so a couple points on that.
That is what he said. That is what he said. So the police department, or I guess the specific agency that did the searching in these databases, in their own policies, it says that they don't do that. And they went against their own policies, and that's not enough. So if the judge knows that, then why are we here? Okay.
First, even assuming that that's all correct and that they violated the
That
terms of
seems to be the evidence.
the terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not.
But that's not the argument. That's not what he just said. That's not what the frickin' judge just said. He didn't say anything about the terms of service on the databases. He said law enforcement's own policies, right? Let me know in the chat how y'all heard that, because I heard the judge say that the law enforcement agency, by their own policies, say that they are not going to use these databases, yet they did anyway. And now homeboy over here is talking about the terms of service on the databases themselves. And I don't believe that that's what the judge was talking about. I feel like that just got switched.
A violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece,
Okay, so the cops' policies are basically saying that if somebody opts out of the police being able to access their information, the police are saying that their policy says they have to honor that. And that wasn't the case, which we've been hearing about all those freaking loopholes that they found out from the beginning. That's what Vargas and several people were telling us about. And then we found the article from CC Moore telling us about it too. And it's basically the cops becoming criminals and breaking all kind of laws in order to get information that's now illegally obtained. Sad.
the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large. So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that
So it doesn't matter if they did go through like some sort of back way. It doesn't matter because you have no right to privacy, regardless of if you opt out or not. Okay.
no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain. And certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that.
But if he was, you just said he wouldn't have a freaking right to say anything anyway. Ooh, I don't like this guy.
That changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document. And if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The US Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these
Well,
things.
if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand it says don't do this, and on the other hand you've got a more general sort of catch-all that says, but we're not really meaning anything we say.
No,
That's actually a really good point. Like, how would you take this if this was a written contract between two people, where one party says that if the other party opts out of something, they won't try to find a way to get that information, and then they go against their contract and they do it anyway? Yeah, you would be like in court suing each other. But this dude's like, it's not the same thing. It doesn't matter. Judge Hippler makes a great point here. He really does. He really does.
no, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide at a crime scene. There is no case law.
Hey, Chris. Yeah, it was wild. I don't know if you caught stuff earlier today, but it's been crazy. Thank you for the sticker thingy. Thank you.
Anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case.
Thank you, Carrie. That's sweet. Thank you.
No one lost their reasonable expectation of privacy. It was seized pursuant to the plain view doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from.
Let me show you guys again, because we have somebody who doesn't know asking if that's Payne. Yes. So this is Payne with the big old shiny head back here. And this is Mallory. And then behind the defense is the two DNA experts that we've heard talk before. One of them is Becca Barlow, and the other one is Lisa Larkin. The one that we don't see is Gabriela Vargas.
From someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever, 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something.
Whenever he said that about it being like not found in a dresser drawer, I'm sorry, but if it was found in a dresser drawer, like actually inside of a dresser drawer, I would probably believe it a hell of a lot more than what they're telling us. Honestly, I would definitely believe it a lot more.
It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals.
Did he just say he? Who was it? Who was it? A male? Was it the guy from Othram? Did he testify? It was a man. We've only had females. Oh no, wait, there was a guy before, wasn't there? Oh, what was his name? It'll be in the condensed point to point video, but I remember there being a guy before. I'm gonna have to go back and check.
He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research." So the defense is positing this question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the US Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA can reveal a bunch of private medical information, and the US
Mercer. You right. Thank you, CH. It was Mercer. Yep.
Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not in fact tested for that end." So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the US Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification. Now, the other problem that Mr. Kohberger has here is, in my view, at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself. You don't get to claim Fourth Amendment standing and then just say, well, that may be my DNA, but I have no idea how it got there. Again, the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing.
Nope. 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 No. The defense has never once said that it was not Bryan's DNA. Have they? No. They've literally come out and Ann Taylor has stood up in court and said that she believes that it was planted there. Does this dude not pay attention? Bryan Kohberger's defense team has never once came out and said that it was not his DNA, that they just want to know how it got there. So how is he going to stand up in court and say that when that's not true? Bryan's team has never said that. Nope. Tell him again, Tiff. Nope. and needs the bald attorney from Rittenhouse to come be co-counsel. Her fatal flaw is articulating her point with speed and conviction. No shit. I mean, she really is like giving it to them today. And Ashley Jennings, just wait. You said you didn't get to see stuff earlier because you were really too busy. Wait and see how Jennings gets the most tongue-tied that you've ever seen her. Her face gets on my nerves. My face is gonna show you how aggravating she is to me when she starts her argument. She gets tongue-tied. She doesn't know how to answer questions. She's making crap up that makes no sense. It is honestly beautiful to see because it just tells you she has no answers. And if this was concrete, if they really had everything that they're trying to say that they have on him, which they don't, she would be able to spit out the answer no matter what the question was. And she does not know nothing that she's talking about. It is insane to watch.
And that is not how the Fourth Amendment works. Your Honor, I also wanted to respond to an argument that was made in the reply brief since I didn't get a chance to do it in the briefing. And this has to do with the trash poll in Pennsylvania. And I'll just start by saying that the defense has offered no evidence whatsoever that would take the trash poll in this case outside of the Idaho Supreme Court's decisions in Donato and Paluzzi. Paluzzi is very recent, came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense here. Obviously, this court is bound by that reasoning. When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that maybe the officers went up onto the driveway instead of collecting them from the street.
The trash company collected them.
Correct. I'm sorry, Your Honor, I misspoke. The trash company collected them on behalf of the officers.
Okay, so this is where we get some information that we didn't have before. So you have to remember, they've been telling us this whole time they didn't have any camera footage of anything. And then we found out a couple weeks ago, I guess it was, that on, I believe, Christmas Day, they were planting cameras on his parents' yard in their property. Now, the trash thing, they've made it sound as if they like snuck some trash out the trash can and snuck off real quick and sent it off for testing. The way that this is about to make it sound is a police officer apparently drives by right before the trash trucks are supposed to come and collect the trash, and that the trash trucks actually are the ones that took the trash cans. And then the police went and did whatever they did with the stuff they got out the trash after that. So, okay.
They just did the regular pickup, I thought. And
Correct.
Pulled over after they got out of the neighborhood and said, here's what we got.
Well, I do believe it was prearranged with the FBI for them to do that. But my point is just, I do think it's telling that they didn't provide the court with these documents that they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that the garbage cans were at the end of the driveway, at the end of the property. And at the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam as he drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection.
Now, I don't know how the rules are in Pennsylvania when it comes to the trash thing. I just always assumed it was the same across the board. If it was not on your property and it was at the actual curb or the road, it was considered public domain, something like that. So me and my ex used to do storage unit stuff and like dumpster dive behind CVS and get all the stuff that they'd throw away that was unopened and stuff. It was like a treasure hunt, okay? We got pulled over one time because we were behind the Dollar General and the cop told us that we cannot dumpster dive in businesses, but you can go into people's trash cans if they're on the street. So I just figured that was like across the board. So I never had any sort of like issue with the fact that they took trash out of the trash can if there was like a warrant for them to do so and they followed protocol for it. And I guess it's like less of a thing now that we're hearing that the trash company is actually the ones that took the trash cans away. But I also have questions about that because what do trash can people normally do? Like the garbage truck that comes by normally does what? There's an arm that comes out the side and it grabs your can and it lifts it up and it dumps it in with the rest of everybody else's freaking trash. Okay, so unless this garbage company physically picked up the trash cans and took the trash cans with them to validate that that trash was actually coming from there. I mean, obviously, they're trying to state that the trash DNA was like the father of the person who left the sheath DNA. But you're just like, you're mixing that trash with all the other trash because now we're finding out that the trash truck took it instead of the cops going into the trash cans itself and like sneaking off with some shit. I love how this is an ever-changing story.
So they, of course, have the burden of establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear. Which brings me to my final point, and that is Ms. Taylor continues to say there was a lot of secretive stuff happening in this case. That is not sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now it is what it is in this case, and we of course complied with all the court's orders and provided the information, but there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes, IGG was used in this case. And yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we're asking to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that?
It's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
There ain't no would be, baby. The state is burdened by that because that's exactly what happened. The judge himself literally just said a few moments ago, that's what the evidence points to. That came out of the judge's mouth. So if the judge does not grant this hearing, and you know what? I haven't checked to see if there's anything on the page. I highly doubt that he's put anything in yet. The case summary, just let me check real quick. And then we get back to that. The case summary was updated today. No. I don't see a new document. Let me check one more time at the very bottom. I just checked the case summary. But let me see if there's another document at all. No. Okay. So we're still waiting on that. But he literally said it. The evidence points towards just what he just asked the state. Would you be burdened by the FBI doing everything I just told you that there's already evidence of? Yes, you would. Damn straight you would. So maybe you should have done a better job as the investigative prosecuting agency and made sure that the feds did what they were supposed to do and produced everything that they were supposed to produce before we got this far. That was your job.
I'll start backwards. I will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what they're doing. It is interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance that trash had.
Supreme Court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case.
How does that change the analysis?
Well, Your Honor, I think that it changes
The expectation of privacy is lost when you put it in the trash can to be taken away, per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
Well, Your Honor, I think that there is an expectation of privacy when you have to comply, you have to put your trash out in that particular manner.
Not the case.
I
Unless you're saying the Supreme Court was wrong, that the Supreme Court was wrong, and you're reserving that for a later higher appellate court, that's fine.
Your Honor, I may not always agree with the Idaho Supreme Court on everything,
But I have to follow what they say.
but I have to make a record when I don't
I
agree.
appreciate
with
that. I'm
what's
just trying
happened,
to make sure we're talking about the same thing.
and I have to distinguish the case as best I can as well.
Okay. But it sounds like they followed the ordinance that she's trying to talk about, right? Because they did have a trash truck come and take it. So it sounds like that they followed that. Did I hear that right?
And I think it is different when you have the FBI telling the trash man what to do. I'll move on to something else. I want to talk about now where Mr. Nice started that Department of Justice interim policy, and he read you the first footnote. And I would just direct the court to pages 6 and 7 in that. And that is that the FBI is not to search databases that they're not allowed to. In this case, the 2 of the 4 that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case. I would remind the court.
I will argue this. I will die on this hill. It was not a freaking tip. It was not a freaking tip. The FBI were boots on the ground from day one. Day one. They were investigating this case from day one. It is not a tip if you are an agency that is actively investigating an open case. It ain't a tip. It ain't a tip.
I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider, just like you would.
And see, you notice how she keeps calling the IGG tip, not a tip itself, an informant. That's why it makes me wonder, like, who was the person that apparently Steve got in trouble for trying to talk to? If the actual informant in this case is the IGG information. Because if that's the way that I'm interpreting this, is that the informant, the confidential informant really is this non-tip, then who could he have gotten in trouble with talking to if it wasn't like somebody actually related to the truth of this and not this part of it? So many questions.
Would in any other confidential informant type of case. I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the 2 SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed and it goes into the CODIS database. This is completely different and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology and the standards that apply are catching up and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that. People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go
Okay, see, this is where she's going to lose me for real, because no, HIPAA and this DNA stuff is not the same thing. Whenever you are submitting your information for your ancestry, it has nothing to freaking do with actual medical information. So I don't really quite understand the HIPAA fight. Honestly, I don't. This is where they're losing me, because they talked about medical information. The state just talked about medical information. And now she's talking about health information. But that's not what this was. This was not some sort of like, this is not supposed to be a database that helped you figure out whether your bloodline has like high amount of diabetes or are prone to cancers. That's not what this was. That's a completely separate thing. That is a completely separate thing to get like a health panel. Half the time they're wrong. Just like these ancestry tests are mostly freaking wrong. But to me, this is not the same thing. And I work under HIPAA. Like I have to follow HIPAA guidelines all day long for my job and be so careful. Even whenever I'm talking to my manager about accounts that we both have access to, if I'm emailing my manager, I can't use like certain parts of the patient's information or the account information, because just sending an email back and forth to somebody else who already has access to the same account, if it's considered HIPAA and I don't send that thing encrypted, I could lose my job. It is that for real. But I don't feel like this has anything to do with HIPAA. This is not the same thing. And see, okay, maybe they got his health info and they shouldn't have. Now, remember, we also heard that he went to the doctor like right after this. And they apparently talked about how charming and nice he was. And they apparently didn't notice any wounds or any bruises or redness or anything on him. And it was like a normal appointment that had already been scheduled. Nothing out of the ordinary. So maybe. Plus, we have the CVS situation where something happened on the 16th. And it's really difficult to figure out what that is, honestly. But I don't really quite understand why they keep talking about medical health and HIPAA in this. Maybe I'm just missing something, but I don't feel like that would have anything to do with this.
Go to the doctor if we want anything released to our surgeon. Health matters are important. If you can upload one of these profiles for $12 and find out all kinds of information, how is that not a Fourth Amendment issue? That's what that SNP profile can do. And that was done twice without a warrant in this case. And there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Thank you.
Muted. Okay. Bryan's apartment search, that was like the night that he was getting arrested. So I don't think that would have been possible if the time that they actually went to his apartment was the only time that they went to his apartment. Because you have to remember what we've been talking about here on this channel since day one is that Dawn Daniels was asking her magistrate court to act as if the IGG information that she told them about in her wanting them to sign the search warrant for his apartment and office. She's asking for them to act as if it's not there and approve the warrant without the IGG information. And that's before Bryan even got back to Idaho. They've been trying to keep this since before he was even back. That's why this is bothering me so much. But I don't think that would have been possible unless they went before they arrested him. Because if the feds had his information on the 19th, gave it to Moscow PD, you think they're not going to go over there, scope out his apartment, look in his office, look and see if they can get into his apartment, look and see if it's unlocked? You don't think that they didn't go over there and try? There's no way that they just didn't go to his freaking apartment in, what is that, like 11 days? Bullshit. There's no way that they didn't go over there warrantless just to check it out. There's no way. There's no way. They wouldn't have just not driven 10 minutes over there to go see where the suspects live in that they just got the name from the FBI of. There's no way. They could have easily gotten his DNA from before we even have this PCA written, because of the date that it was written and the amount of days in between and all of the bullshit. Just so many questions. So many questions.
All right, the matter will be taken under advisement. Let's proceed with the Frank's argument on the IGG and the
Frank's proffer more generally. Or did I get it wrong again?
Your Honor, I'm prepared to do that. I would request that the court maybe give me 5 minutes. I have
Okay. I've been seeing people talk about this a lot. I'm gonna have to look at that and see why that is such a big topic right now about the cannibalism law. I mean, the fact it has to be a law is really sad, but I mean, they gotta make laws that tell you can't marry your first cousin, so it honestly doesn't shock me.
different things.
We'll take 5.
Thank you.
back in.
David's that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger. And without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on. So
We did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
my only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can then. Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the
Hurricane Train, that's a cool name. Thank you for joining.
FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger. He had not crossed their radar. That's nowhere in the affidavit. And that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing.
Exactly. Exactly. The feds messed up so bad that the police department knew that they had to do this a certain way in order for all of the mess ups that the feds did not to cause so many issues. How is it possible that they did so many things in this case for a month and a half and had no freaking clue about Bryan if he was actually the guy? They have all of these pages in this PCA of all of this evidence and all these things, but they didn't have any of that pointing to literally anyone before they had this from the feds. It's literally impossible to believe that it's Bryan. Literally impossible. Yes, 16 months. Holy molies. And yes, very crazy. Absolutely crazy. Absolutely insane. We need a new word. Honestly, we really need a new word.
Because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did.
I'm actually really glad you brought this up because I've been saying this for a minute now. The person, the aunt that said anything about Bryan being vegan had been divorced from the family for like ever, literally forever. And it literally everything that she said about how like basically anal he was about them not cooking with any pans that ever touched meat ever goes against their theory that he met Kaylee and Maddie over at the freaking Mad Greek because he went over there to get some sort of vegan dish because they cook lamb up in that freaking place. Okay. And if he really did not want to eat off of dishes that meat had touched, he would not be going into a place that only had like 1 or 2 vegan dishes, but cooked lamb, and be able to eat that food without having a whole like panic attack the way that this aunt was talking about. So it literally might have just been something that he was doing in the time frame that he was losing all that weight, because it's been that long since she was married to the family. So Chris is right. Like, that lady had no verification at all. Oh, thank you, Chris. Oh, 20 memberships. I want to see how many people actually grab them. It's really cool that they allow people to do that, because all of a sudden just like starts going crazy and people turn green. Thank you so much. That's awesome. You guys tell Chris thank you. That's great. Thank you.
To identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing probable cause, that would have been really important to understand. We don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that. That may have given the judge caution. It may have made the judge wonder, what else are they doing behind the scenes? But that was withheld from the judge. That judge never got.
And see, I've asked that question too. Like, I know that you're basically supposed to just like believe that the cops are doing the right thing and they're giving the judge information that is truthful, right? Like, you really want to believe that. But I haven't really found anything that tells me that the judges that read these affidavits, that sign these warrants, do they actually fact check what they're reading, or do they just take the word of the cop giving them the information? Do they just take their word for it? Do they double check it? Because it doesn't sound like they double check a lot of anything. Moonvale gifted 5 memberships. You guys are going to get all membershiped up today. That is awesome. Thank you so much. You guys are great for being here too, because this was some hours and we sat here forever earlier today. But dang. And yes, there's like a setting, guys. I honestly don't know how to make it work, because on both of my channel, because I have like this one and then like my little personal one that's I'm really not ever like having time to do anything for, but on both of my channels, I do not have the option in the settings to turn on gift membership thing on any of mine, but there's a setting. So if there's anybody that can like put in the instructions on how to turn that on for people, because it doesn't work for me, so I don't know how to tell people to do that. I have no idea. But there's supposed to be a setting where you can actually like accept a membership. I'm just not sure how to get to it because it doesn't work for me.
Got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that, and if the court has some of the initial exhibits, the court will know, and I'm at D2. The court will know that this was a group effort. The FBI, the same FBI that went behind and violated their own policy to try to identify somebody, they were co-located with Moscow Police Department and working on these affidavits to present.
It was muted. Thank you, Jennifer. That's very, very sweet. Thank you. Thank you for caring enough. Like, all of you that are here doing this right now, y'all care about facts. So y'all already like the good portion of humanity, just so you guys know that I appreciate the fact that y'all are here caring about all of this stuff. Patricia, 5 more memberships. Thank you. I'm so glad that you guys have like created such a big community here of people that actually care about all of this stuff. So many people are just falling for so many crazy things that aren't true, and they just take craziness and run off. And I'm so glad that there's so many of you that actually care about what's happening here. This could be anybody. This is insane how far we've gotten with this. Literally the most ridiculous thing ever. Miss Mojo Ryzen, thank you so much for the super sticker. I wish StreamYard would let me see what it looks like. I don't know why they haven't fixed that. I don't know why. Insane. Thank you. Thank you so much.
To the judge. The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems with that warrant. This probable cause affidavit talks about
Honestly, take this how you want, because I'm sure that some of you like some creators that use the soundboards. I find soundboards so cringy. And I don't use that word often. But I find soundboards just absolutely wild.
an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false.
Get ready. Get ready. You ready? Get ready to hear some shit that you probably are not expecting to hear. Thank you so much, Mads. 5 more memberships. Thank you so much. You guys are great. You guys are awesome. I'm trying. I'm going to try, I promise. I know you guys have been telling me that since I stopped, that y'all want me to do it more often. I know. I'm going to try to make it happen more often, and they won't run this late. I'm going to try to do it more on a schedule. I'm going to try to do it more on a schedule. I promise. I promise.
False in many places. The way the affidavit reads, it says this person stated she went to sleep on the 2nd floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after.
And also, I want you guys to help me catch this. Later on, whenever the state is counteracting this, the state mentions that it's Dylan. I don't remember Anne saying Dylan. I remember Anne just saying this person. And then because of the way that she's talking about it, it's like, duh, it's Dylan. But Anne doesn't say Dylan. Help me figure that part out, because that's how I remember hearing this.
911 was called in the afternoon of November 13th, 2022. And she was sure. I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit.
A victim. A victim. Apparently Dylan, is telling them that she heard one of the victims running up and down the stairs. And then we have to remember what's going to come out later here is that there was unknown male D with blood on the handrail of the same stairs. Like whichever one of these victims it was also running down. That did not get. How do they know? How do they not test that? How do they hear this? That one of the victims was running up and down the stairs, have a blood on the handrail of the stairs, and not test it to find out the name of the person? How? How do you know that the truth is that's what she's saying that she heard and you don't test it? I don't understand. Thank you so much, Heron. That's very sweet. Thank you. You're the best. Thank you for all your hard work. I love the way you present and give your opinion. Thank you. I feel like so strange reading stuff like that. Like, I kind of just want to like read it like in my head, and because I know I'm gonna like, it's hard for me to like read compliments, but I appreciate you guys very much. I'm gonna try better to read these things out loud, because I know y'all get like kind of lost whenever I'm just like talking and I don't show what I'm talking about. I'm trying to get better at this, guys. I promise.
Affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. And I've got one more of these where this is repeated. It's repeated again in D8C as well.
So Dylan claiming this, hearing a victim going up and down the stairs, is repeated several times. Well, the truth doesn't change. So if that's repeated several times, why don't they have something like that in the PCA instead of making us believe that she didn't hear anything? That's wild to me. Now, I do see that some of you guys are saying that if that is true, that it could have been Xana. I mean, very possible. Because, I mean, maybe it could have been Kaylee. I don't know. It's just a simple fact that they know this. It's repeated in several times that she speaks, and they don't test the DNA on the stair rail. I don't understand. I don't understand.
That is important because that's misleading to the judge. That water
Okay, Danny has how to turn that thing on. Do I need to slow it down? It's not going fast for me, but if I need to slow it down, I can try to slow it down. I don't think I've done that before. Let me try. Let me look in the back end over here and see if I can figure that out.
waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they
We're going to get that part again. Thank you, SD. That's very sweet. Thank you. Thank you so much. All right, let's listen to this part again. It's not too fast. Okay, did she just say DM? Okay, that's why I wanted to go back because I thought maybe she did. But I want to hear this part again because remember, the coroner, Mabbitt, has been saying this entire time, oh, they were all in their beds. They can't give us true time of death, which the excuse they're giving for not being able to give true crime of death. What are you even like working in that field if you cannot give us time of death without making excuses? I'm sorry, you're full of crap. Full of it. Completely full of it. So let's listen again.
were co-located with Moscow Police Department and working on these affidavits. That is repeated during this same interview a couple of different times at page 287. It's also
Thank you. That's very sweet. Thank you, C just C. Haha, that's funny. Thank you.
repeated in a subsequent interview that same day. This is defendant's exhibit 8B. That's at page 313 and again at 320. I've got one more of these where this is repeated. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers.
I'm trying to understand it. Okay, so is she stating that the statement from Dylan about who was running up and down the stairs is false because that person was taken out in the bed and never left the bed? Is that? Let me one more time. I want to get this right.
A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is defendant's exhibit 8B. That's at page 313 and again at 320. I've got one more of these where this is repeated. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit, because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so
is she saying this? I'm trying to understand what the hell she's saying. So she's saying that Dylan was saying in interviews and has repeated several times in interviews that a very specific person was running up and down the stairs upright, but that can't be true because that same person was actually taken out in the bed and never left the bed. But how do they know? How do they know that? How do they know that the person wasn't running before landing on the bed and being taken out on the bed? So was somebody actually running up and down the frickin' stairs or not? Because if Dylan repeated it 1.5 million times, well, not 1.5 million times, but if she repeated it in several different interviews, in several different exhibits, but now Anna's saying that the police officers knew that what Dylan stated about the person running up and down the stairs wasn't true, well, then technically what's in the PCA would be more true? Am I like comprehending that right? Maybe one more time.
it's not at all what was said. And it's for 48 hours worth of records
Not that far.
within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places.
See, okay, so that makes it more confusing. So she's saying the PCA is wrong because there's several instances where Dylan says somebody is running up and down the stairs, but then she's saying that that's false. I'm very confused.
The way the affidavit reads, it says this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go up the stairs, and then come running back down the stairs. That is not.
It would be Xana. It would be Xana. If it was those stairs, because there's 2 sets of stairs. But I don't think Dylan would have heard if Bethany went up. Could she have? Could Dylan have heard if Bethany came out of the bottom floor, came up those stairs to the 2nd floor, and then went back down? But she wasn't considered a victim. And Xana and Ethan would have most likely been on the 2nd floor. So it would have had to have been Xana that went up the stairs and then came back down. Running, which is why it would have been louder. But see, I don't think it could have been the DoorDash, because you wouldn't be going from the 2nd floor to the 3rd floor to get your DoorDash. You would have gone downstairs to the 1st floor, right? Exactly. The fact that the house is gone and now we're hearing about this stair business, but I'm still trying to figure out what the hell she's trying to state right here. This is going to be a portion of this that I'm probably going to have to go back and try to listen to separately, because I'm really not understanding her point. She's saying that the PCA is incorrect and lacking information. And then she tells us about the running it up and down the stairs. And then she says that the police knew that whenever that was being stated that it wasn't true. Okay.
Not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is defendant's exhibit 8B. That's at page 313 and again at 320. We've got one more of these where this is repeated. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit, because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because
And to see, that makes it even more confusing because it can't be Xana, because Xana was on the floor up against the wall, according to the way that the detectives saw as they were walking towards Xana's doorway, that she was able to be seen across the room, up against the wall, through the open door. And that's normal. Like whenever you're walking towards the door, they're in the back. Like you can see through the door, through the, like all the way across the room to the opposite wall. That's normal whenever you're walking towards the doorway to be able to see across the room. So it couldn't have been Xana. Yeah, it has to be Maddie. Exactly. It would have to be Maddie. But that still doesn't make any sense to me unless she really wasn't in her room whenever all of this started and then she landed on her room. If they're stating that it had to have been up first and then back down. Yes, it's all lies. And what's up with the upright thing? Y'all are right too. Like, why are you talking about they were running up the stairs upright? I guess they're trying to state that she wasn't like somebody wasn't falling down the stairs, that they were intentionally making those steps. Maybe that's the point of the upright thing. Oh man, this is why this house should not have gone anywhere. I don't give a damn about their 3D scans or any of that crap. This is insane. Absolutely insane.
because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had too much to drink and couldn't remember. None of that is.
And see, that's another thing. We have not ever known anything really about where Dylan was that night. Like at all. Like at all. Like literally at all. They haven't told us anything. So we really don't know. We had no idea if she had been somewhere partying, which Saturday night college, most likely so. Most likely so. But this does matter because they basically are using the bushy eyebrows as like this whole reason why Bryan is the guy, just for you guys to find out here in a minute that whenever Dylan looked at a picture of Bryan, apparently she didn't recognize all those old eyebrows as being the ones that she saw. So that's important to note.
Is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things. And
no, I understand what y'all are talking about. There's some of y'all talking about this, but that's not what she's talking about. She's talking about the person that was running up and down the stairs was running up and down the stairs upright, like they were actually physically making the motion of the running up and down. I don't think she's talking about the position that the body was later in. I could be wrong. I'm going to have to go back, like I said, and go back and listen to all of this and make sure that I'm understanding her, because I still feel like she's kind of flip-flopping a couple of things. Because I still don't know if she's trying to say that Dylan actually did see somebody coming up and down the stairs or not. Very confusing. Welcome, Mikey. Long time no see. Hey, boy. How you doing? Thank you for joining. But I don't know. I'm very confused. Oh, and a gifted membership. You're awesome. Thank you. Thank you. But yeah, this is definitely going to be something that I'm going to have to go back over because this is wild. Hey, architect, how you doing? Yeah, this is wild. So much more information, but it gives you like a bigger visual of things. But it also tells you more of like why Dylan is not coming back, because you're getting all of the information that you've got right now that she damn well knew something was wrong and the cop should have been called. And then you get some sort of inkling about what it could have really been like for Ethan because of him being behind the door and the door apparently having to be pushed open and all this other stuff. But that's really just a story that the Goncalveses are out here talking about. I mean, it's a very big possibility that even Hunter Johnson was lied to. I mean, if you're willing to not call 911 for 8 hours and there's like no trail of anything and you're being secretive and you're not wanting to come back across state line, even though, you know, they want to act like they got the guy, but what you scared for if that's him? It doesn't make sense. I feel like she really knows that she's about to be in a lot of trouble and she's trying to get out of that trouble by just like agreeing with whatever's going to be happening because they know that they got to arrest somebody. And the school did everything they needed to do to cover up whatever was really going on, in my opinion. This is insane.
The magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion. Your Honor, the next part of the affidavit talks about what they have determined to be suspect vehicle number 1. And it trails a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing and we know what it is. It's around this particular area.
So what I'm getting from that is that the camera that shows the 3-point turns and all the things they're talking about in the PCA, that it's too, I guess, bad quality, and they really couldn't determine what that was. There's nothing to really determine that very specific car's make and model. That's how I'm understanding that part.
The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in D10. That's in D9. And finally, after several submissions, that's when the FBI IML says, I can make a car identification.
Several submissions. So it took a whole bunch of footage of all different cars, apparently, because they still have not been able to prove that the cars that actually like went along actually were the same exact car. And we've already heard in court them claiming that the vehicle at the cannabis shop in between the state lines, like on the highway, that's not Bryan's car. And it's part of the evidence of the car they're trying to say went to Moscow from Pullman, and it's not. It's not.
The issue with that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car where it appears again. It appears one time. And then what law enforcement did was they took several videos from all over the area and said, well, it's the same car and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. And that's what law enforcement relied on. The court has, it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13.
Exactly. If they were so confident that they had the car, then why did they show us stock photos instead of giving us a still shot? And I don't care what anyone tries to say. The car from the gas station that came out from Brian Inton was just as crappy as the light video in the Sebastian Rogers case. Brian Inton went in and took a picture of a screen on his own cell phone. It was not taken by the cops. He even says himself, whenever he tells the public about this gas station stuff, that the cops did not have this. And I also wondered how they were even able to really truly get it, honestly, because unless the person at the gas station actually had like a way to download that thing themselves onto like a portable device, all of that apparently also was like, it records over. It records over. And it was like weeks after the event that this gas station car even popped up. And it don't even look like the right car. Honestly, the damn thing doesn't even look like it has tires on it. It doesn't even make any sense. And the year of the car that we were all supposed to be looking for wasn't even changed until after his arrest and the PCA came out. Then all of a sudden it matches exactly what Brian has. And for those of you who saw the last video I put out about the car, about how the private driver apparently had like a list of like 10 or 11 cars that he turned in, that he lived like 1,200 feet apparently away from Brian in Pullman. And even he said when he first saw Bryan Kohberger's car in the parking lot of that apartment complex, that he even himself, he thought that it was too new compared to what they were claiming that they were looking for. But he still wrote the license plate down. But even him, he was like, yeah, it looks too new, but just in case. It's just too much. There's just too freaking much.
Hyundai Elantra. And that's what they're looking for. And they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the magistrate believe that they have a clear view of this car making this loop. And that's just not what happened. It's pieced together and it doesn't make a whole lot of sense. Law enforcement in their affidavits talked about this dog barking, and they key some time, and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here, and they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly.
So not only do we have the forensic download of Dylan and Bethany, putting the timing of the end of the crime at 4:25, which is 5 minutes after they're claiming that their suspect vehicle actually left the scene. But then we have what ends up being like 25 to 30 minutes straight of nothing but Murphy barking his head off, that it just like starts at 4:17. So let's just like round it. That's like 4:15 to 4:45. So if that's like the case, then that's like 27 minutes after the suspect vehicle leaves the neighborhood that Murphy is still barking his head off. That's important.
Abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later.
Okay, so I did hear that wrong earlier, because I could have sworn they said that the victim's doors were all closed. So, shit. Okay, so at this point, if the story, because this is the only thing that we can really go off of, guys, is if the story that Kaylee Goncalves has came out and given Daniel from Stupid Drunk Turkey, that if anything that she was told is true, then Hunter Johnson would have had to have come over and forced Xana's door open because it was originally closed. So this still doesn't tell us how the scene was actually found. Honestly, it really doesn't, though. This is just telling us the way, I guess, that the first responders saw it, but that's not maybe the truth about how it was maybe left from the way that the perpetrators would have left. because we're hearing that Xana's door was unable to be opened by Dylan and Bethany, so they had to call somebody else over. But then again, I've always questioned, well, why didn't you go upstairs and see if Kaylee and Maddie could help you if you didn't know what was going on and you just thought something was wrong with Xana and Ethan and you needed help opening the door? Why'd you call an outside source instead of calling the girls upstairs unless you knew something was going on? But then we also heard what? We heard that whenever first responders got there, they didn't even know they had to go upstairs to look for Maddie and Kaylee until after they asked the Dylan and Bethany and Hunter if anybody else was in the house. And then that's where they're like, holy crap, Maddie and Kaylee. And then they go upstairs and they see that. That's how we've been kind of told that this is played out. Yeah, no mention of that besides what we've heard. That they had to be asked, was anybody else in the house before they even knew? And if that's the case, then why? Explain to me why the girls didn't go upstairs to get them instead of calling Hunter. Explain to me that. Nothing makes sense. So all the doors were open. All the doors were open. And Murphy had no blood on him. Nothing on him. And why would he just abruptly stop barking and never start barking again? Well, I guess they don't say that he never started barking again. But to bark for 25 to 30 minutes and then it just abruptly stops. I think somebody said it, like the dog maybe saw Dylan, somebody that they felt comfortable with, and stopped barking. Bro, yes. No freaking paw prints. At least nothing that they're telling us. Jeez, man. No, none of this freaking math is freaking mathin'. None. This is just as complicated as my damn algebra, whatever crap I kept trying to freaking pass whenever I was in college. This is the most complicated thing. None of this adds up.
The magistrate is not informed about that either. Then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop, 2 traffic stops actually, and there's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation.
I mentioned it earlier, but I'll mention it again because we've got quite a few people in here. I've never had this many people in here. Ever. So let me repeat it. I tried to FOIA very recently the August 21st pullover that they mentioned in the PCA because we've been being told this entire time that he was by himself. And it just doesn't really make sense. If he was by himself, why would they not let us see it if they let us see the one in October and we have the body cam footage from December 15th, the 2 stops? Why wouldn't they let us see this? So I FOIA'd it very recently. I can't remember. Maybe like last week I posted the video. I honestly don't remember, but it's definitely been less than 2 weeks. But I FOIA'd that thing and they instantly got back to me within like a couple hours and said no, because it could be something that could basically cause Bryan to not have a fair and impartial trial. Was like the, she attached the reasoning. And I just don't understand that, because if he was really by himself and then we took the points and we looked where this actually was, and it's a busy area. Like, how whenever you're traveling and you're traveling through a city, but you're traveling on like I-10 or on 35 or a big highway. So you're passing through the town on the highway. And so you're just seeing like nothing but a bunch of like shopping stuff and restaurants, like all along the highway itself. That's basically where he was. He wasn't anywhere. It was nowhere near King Road. So I just don't understand why we still can't have that information. If he didn't say anything, if he was by himself, if there's no connection between him and the victims, meaning he's not going to say anything that would be anything to do with the victims, why not show us that? Why are we not allowed to see the August 21st traffic stop to this day, even though they're proving that there's nothing to connect it? What's the point of not showing us that? And why is it in the PCA? Why? You guys go back to the go to the video and just like scroll to where you see the Google map. Because all I really want you to see is where it is compared to where it is on King Road. And it would have literally been like he was like driving out of town. Yeah, like he was driving out of town. He was just on the busy highway, like doing some shopping or whatever. Like, what's the big deal? What's the big deal?
But those are put in there to try to bolster up this investigation and say it was something that it wasn't. Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Bryan Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't.
So it was after the 19th that they got the information about the August 21st stop. I mean, that would have to make more sense because they had nothing pointing to Bryan before they got the IGG information. So why would they have had the information on the August 21st stop prior to the 19th? See, that just proves even more that they had nothing pointing towards him.
Doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective. And if you look at the messaging between the detective and the WSU police officer about the timing of that. So it's based on this false investigation trail, and it's
Times 4. Not just blood, it's everything that the body lets go of when it comes to the liquids and the gases that come out of the body, times 4. But then we also have to go back to which of the other doors were actually open, because the Goncalveses, or at least Christy, told Daniel way back whenever she told him this story. And for those of you who don't know all of it or haven't heard of it, there's like 2 videos that I did about this because there was some very important information that Daniel said whenever he was doing the live, because he basically like clickbaited the whole freaking community and acted as if he was going to actually do an interview with Christy live, like on his channel. And it wasn't. He just got out here and just like said the question he asked and then repeated her freaking answer. And then nobody believed him. So she had to do a video that he had to post where she said, yes, it's me. I talked to Daniel on Drunk Turkey, because like nobody believed him because he was just stupid about the way that he gave it out. So whenever he ended up getting rid of that video and then doing another one that had some information missing, there was some for real information about Dylan that was not repeated again. And I was like, hold up, bro. Why are you not repeating this? Because this is important. And this is where this whole entire story came from. And the rumor originally was that one of the neighbors said that the front door had been wide open hours before the 911 call. But whenever that situation was addressed with Christy, she said they were told that it was the slider that was open, that it was the back. So you're sitting here telling me that the back door and the front door were wide the frick open, that all of the victims' doors were wide the frick open, and that Murphy's door, or Kaylee's door with Murphy, was also wide the frick open. And the G said that his crate was still in Kaylee's Range Rover. Okay. So that meant that he could have literally like free roamed even out of that freaking house, and he didn't. If that's the case, if both the doors were wide open like that and every other door was wide open too, like I don't understand why none of this is concrete. And see, to let the smell out, yeah, but then what we heard from first responders is that the smell hit them in their faces. I'm so more confused. I swear. The Goncalveses need to start asking the right questions because they're the ones who are out in the media the most. And if they really want justice for their daughter and for anyone else involved, they need to be out here asking the same questions that we are asking, because none of this shit makes sense. This is so impossible. All of this is impossible.
Based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge.
So that's what it was. This is what, this is what she was saying earlier, was that parts of this, Dylan wasn't sure whether it was real or not because of how drunk she apparently was, how intoxicated she apparently was. But that also goes to, if you thought that it was a dream, how bad was it where you thought that it wasn't reality? How bad was it? You thought it was so bad that you were asleep and this wasn't really happening? How bad was it? So that means the story just kept changing with her to where she thought she heard something, but maybe she didn't because she thought she was dreaming because she was too intoxicated. It doesn't make any sense. Doesn't make sense.
If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
If I find that the IGG was not unconstitutionally obtained, doesn't it just add to the probable cause?
No.
If it were to have been disclosed, it would have simply created more basis to suspect Kohberger.
Your Honor, if it had been disclosed, think about how that would read. We used a process to make an identification.
I don't know. They haven't told us anything about Dylan, about where she was. Nothing. We don't know where she went. We don't know if she did stay home and had people over. We don't know if she went out and drank at some bars. We don't know if she went over to somebody's house and drank and then came home. We don't know nothing. You heard me? This far along and we know nothing. There's no reason for us to not know basics. No reason at all.
This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was. So we just ignored that policy altogether. I don't know how a judge could find that credible. You don't even know how that happened. There is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you don't find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at
I remember whenever we first started talking about this case, and it was literally within like 2 days, I think, of it, like maybe 2 or 3 days of it becoming like a situation. Because of my channel, I started my channel, I believe it was in August with Kylie Rodney's case. And it was like not very long after that we started talking about the Idaho case, and it was pretty much like the second that it was announced, because it just like blew my mind. But one of the things that I remember thinking to myself whenever we were talking about the dog was, is it possible that he was injected with something or given something to shut him up and make it easy? Because there were so many questions about the dog. And now hearing this is like, it's kind of like bringing me back to that, especially whenever Ann Taylor just said that the Murphy's barking for 25 to 30 minutes and then just abruptly stops. And I can't help but think of like Dexter type injections that could also make it really, really easy to subdue somebody. And there's a lot of things that you can inject into people that do not pop up whenever toxicology is done. College students would probably be smart enough to look those things up. I don't know. There's just been a lot about Murphy that I've had questions about. But the abrupt stop of the bark, that's kind of like bringing me kind of like back. And I really wonder if did they take a blood sample from Murphy and test him for anything, considering the fact they're trying to tell us that everything was freaking wide open and he was perfectly clean. I mean, it kind of tells me that he was like asleep, passed out the whole time. Like, come on. You're telling me that a dog is going to be in a house with 4 people that have now expired and there's just stuff everywhere, biologics all over the place, and they're just going to stay quiet for 8 hours, 25, 30 minutes of continuous barking and then just nothing. I'm really curious if somebody gave something to that dog. I've been wondering that from the very beginning, and I've kind of let it go for a while, but this is bringing that all back. I really wonder if they drug tested that dog.
What a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on. If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that.
See, I'm glad that we're going back through, because whenever she said this earlier today, I mean, obviously it was happening live, so I wasn't about to even like try to mess with it or nothing. So I just kind of like mentally noted it and then went on, because to me, I was like, damn, is she talking about a photo in the case? Somebody threw away a camera, they took a photo of, there's no evidence. No, she's giving an example. So I'm glad that I know that now, because I thought she was for real about something for a second, but it's just an example.
And by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that. And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
The purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front.
Okay, so that's the example. If that's the truth, bro, okay, maybe I need to email Hippler and send him the timestamp where he said this himself. If the entire point, I mean, well, maybe he's talking about the October one. Is he talking about the October one or the August one here? I guess it would have to be the August one because she just said seatbelt ticket, and that's not what we saw in the October one. So it would have to be the August one. If the August one really truly is only for the identification of Bryan's car and about the positioning of the license plate, then why the hell am I not allowed to have the information? Why am I not allowed to have the information if that's the only reason was to identify the type of car that he drove? That doesn't make sense why I can't have that information. That doesn't make sense at all.
Wasn't to suggest it's otherwise connected to the homicide, except to say this is a car of interest and the defendant was found driving it.
Well, let's talk about that license plate for a second, though, because that's not something you can see from the videos. And that was testimony you heard today. You can't see that from the video.
That's actually makes the most sense, because even whenever we have the video from October, like the cop is behind his car. And just like with this one, the cop would be pulling up behind Bryan's car. And the whole situation is that it's a front license plate issue. So for her to say that you can't even see that, that makes perfect sense to me, by the way that I know that cops come up behind your ass. Why would you be able to see if there was a front license plate or not? Especially since, when do you ever have a cop pull you over and he walks into the front of your car? He comes up behind you, he touches the back of your vehicle because that's just like a protocol thing that they do, and he comes up to the side of the window, and depending on if you're on a highway or whatever, it just depends on which side they come on to. But I never had or ever seen a police officer go in front of your vehicle during a traffic stop. So I guess that makes a lot of sense. You wouldn't be able to see if the front plate was legit. So that takes away the relevancy of this August pullover and makes it even make less sense. They won't let me have it.
Cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU.
So it was not known before the IGG about the front license plate issue. So did they only mention the year range and the white Hyundai Elantra? That they don't mention the front license plate before the PCA? I guess they didn't, right? I don't recall that. I don't recall that at all.
Before. There was no communication with the officers at WSU before. So if
I gloated the shit out of this earlier. It's the one time that I will be like, literally, nanny, nanny, boo, boo, Daniel, because you were freaking wrong. Daniel has tried to say that they have known about Bryan Kohberger since the 11/29 boo boo that we saw in the PCA, where the two WSU officers or whatever saw the car in the database for WSU, and then 30 minutes later, somebody's putting their eyes on it. I knew from day freaking one that they did not touch that tip, that it got buried somewhere, and then it got pulled out after they had Bryan's name because they were trying to get as much crap as they possibly could. Daniel has been acting like this was like patient zero when it came to Bryan's investigation and him becoming the suspect. Okay. No, I've known in my freaking heart of hearts from the very beginning that this tip was buried somewhere, that they didn't check the car. They didn't do none of the things. It didn't matter that somebody saw it in a database and 30 minutes later, somebody saw it in a parking lot. The cops didn't give two shits because they didn't know about it until after they had Bryan's name. They didn't care. So Daniel's been wrong about that this entire time, just like he's been wrong about so many things with his guilting crap, and he refuses to take the truth and actually do what a cop is supposed to do. He was wrong. That 11/29 thing literally sat there for a month because Bryan wasn't arrested until, what was it, the 30th? Wasn't even the whole 31st. It was the 30th. More and more proof they literally had nothing pointing to Bryan until this family tree was fabricated out of nothing.
if before the identification through IGG.
I'm just not tracking why that matters. Go ahead.
It matters because this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you. I do want to comment on the affidavits being used by a variety of officers. I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off.
I'm still in the process of getting the comparison video of Blaker's PCA to Payne's PCA. I had like 90 minutes of it edited down. Like I had 90 minutes of polished, ready to go footage and still had probably like another 2 hours, like not even gonna joke. It's gonna be hella long when this thing is done. But I lost that 90 minutes. I had to start over. And now I'm back at that 90 minutes. But now that I've done that part, there's some stuff that we just learned, and I'm sure we're going to learn more tomorrow, that I'm going to have to go in and edit some things into that portion. And there's just been so much new stuff happening in this one. That's another reason why it's not out here yet. But we are going to do a huge, huge thing. And it's probably going to be like a premiere, I guess, so that I can be in chat with you guys, because it's going to be hella long. Like, it's going to be so freaking long. It's going to be so long. But it really is like difficult to even tell like who actually wrote the first one, because parts of it makes it sound as if Blaker's was the first one and Payne copy and pasted stuff from Blaker's into his own. But then there's parts of Payne's to where it's like, well, shit, maybe Payne's was the first one, because this makes it sound as if Blaker copied and pasted it into his. It's really hard to tell. She's not wrong. It goes back and forth, and it's really, really difficult. It's annoying to try to go back and forth with, but there are enough differences in there that makes you really question some stuff, especially whenever it comes to Ethan and Xana, because one of them has like an end time to certain information and the other one doesn't. And there's a couple other differences too, but for the most part, it really is like copying and pasting down to their experience. They're copying and pasting their own experience when it comes to how they're coming to their opinions. And that's one of the biggest issues I have. Like, you're basically straight up lying.
And who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Bryan Kohberger's phone. They do acknowledge that his phone wasn't contained within the geofence when they looked at the geofence. But the second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find.
See, more proof of reverse engineering. They didn't even think to go and check the WSU security cameras to see if that suspect vehicle number one they were oh so curious about might have been on any cameras in Pullman. They didn't even bother. Didn't bother one bit.
A white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard, where one could turn to go to Moscow at 2:42, is inconsistent with 2:44, but they don't correct that. They don't correct that. They don't say.
So it's off. It's off by 2 minutes, and that's a lot. That is a lot for such a short distance. So they're saying that the white Elantra on the cameras makes a certain turn at a certain area 2 minutes before Bryan Kohberger's cell phone data basically puts him in that exact same spot. 2 minutes is a big difference, especially in a moving vehicle.
That vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m. They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records.
So y'all heard that, right? The PCA claims that Bryan's phone went off network at 2:47, but the actual information that was given to the defense in the discovery says that the actual time that his phone went off network was at 2:54. That's like 7 minutes. Do you know how freaking far you can get in a car in 7 minutes? Are we for real? Now, let's also go back to the fact that Ann Taylor's already stood up and said in court again that the cannabis shop in between Moscow and Pullman that has camera footage of what the state is claiming is Bryan's car, it's not. It's not Bryan's. So they have the cams 2 minutes off to the phone records when it comes to turns. And then they have a whole 7-minute gap in when his car actually was in a certain spot compared to when his phone went off of network. The entire PCA is a freaking lie. None of the numbers are right. If the beginning numbers start off wrong, then every single number after it is also wrong. How are the Goncalveses just sitting back and not trying to make a fuss about this? I don't get it.
And that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about two towns that are fairly close together. And so the way a car points when they go off the network matters a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that that phone wasn't traveling in to create a false narrative for the magistrate to rely on to find probable cause.
So she's talking about that really crappy horseshoe thing in the PCA. I mean, Payne already got on the stand and said that that was just a guesstimate, which we already knew. We already knew that none of it was factual. It's literally all just a bunch of guesswork. There's literally nothing in the PCA whatsoever that is actually concrete with proof. None of it. None of it. Literally none of it.
Your Honor, I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28. Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records, but based on those records, they absolutely knew.
Look at Payne's bald ass. He's texting somebody on that phone. His hand just like disappeared. So he's reading something, I think. I've been trying to like catch him. I wonder if what's his face, if the judge is going to go back and be like, bro, who were you messaging on that phone? Who are you talking to?
That Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible.
Look at him. He's doing it again. He's doing something. I'm gonna have to go back and I want to take count now about how many times he goes for that phone. That watch.
Has memory problems, and the judge never knows that. And we'll keep the IGG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that.
So I'm glad, again, that we are going through this entire thing because for those of you that were here earlier, y'all know damn well when she said that, we were like, hold up. Did she just say that he was there that night? No, he did not say that's not what was said. Just that he had been in Moscow before, which they cannot deny that he's been there before because we have a pullover in August of him being in Moscow. So again, I'm glad that we went back and listened to that because I really thought she said something about him being there that night. And I was like, hold up, wait a minute. And that's not what was said at all.
We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I'm thinking of a different date for the AT&T. I thought, not the cell tower stuff. So you're still talking about the cell tower stuff?
no, I mean, that stuff applies to every single warrant we have because that was
I thought
early.
you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the
What is
individuals.
that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA and the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
No, it is maybe probable cause to interview somebody, but to SWAT team the shit out of their mama and daddy's house and break everything for the sake of something that has no freaking evidence in it. No. You're going to like hear, because they haven't said it yet, but you're going to hear that there was blood, unknown male DNA found on the handrail of the stairs in the house. So how are you going to sit here and try to tell me that touch DNA that could be picked up by him literally just taking the same gas nozzle into his hand before the actual perpetrators maybe touched that exact same gas nozzle? Okay. How is that probable cause for all the bullshit that they did here? But having blood on a rail where 4 people were killed and it doesn't match your suspect or the male that died, how is that not probable cause to keep on going till there is a name? But this is probable cause to do an entire cross-country investigation. No. Mm-mm.
Not in this context. Not in this context because of the IGG work, because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Killed by a knife, that probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other.
No, there's footage that shows a white Hyundai Elantra, but there's nothing in that footage that makes it Bryan's car. I pulled that up on the map earlier. If you go back and look at the live that we did whenever this was live, I like popped in pieces of the map that showed exactly where that house was. And it's like King Road is over here, and you leave the area and go all the way over here this way, and then come back around and like loop down a little bit. And it's like a big old house. And it's actually not a house. It's like apartment condo type things. I showed it earlier, but it does not, I don't believe that it said that it identified his car, because they've never been able to positively state any of the footage shows his car. They've already proven that. The state themselves have proven that.
Other factual information that the magistrate should have known. I think that there's a lot of pause, even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with a car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment, as asserted, but I'm not sure how that precludes probable cause.
3 months. Hey, Steph. And yeah, Claire Bear, thank you for reminding me. We heard, if this is the same one, which I'm not sure if it's the same one, but we did hear that there was footage of a car going the wrong way at the wrong time. But we've also already heard that there's only one camera that shows the white Hyundai Elantra at the crime scene, and that there's like a 13-minute gap in between the car being on that camera and where a similar car pops up next. 13 minutes is a long time. I'm pretty sure 13 is what's said.
When there's a direct DNA match, there's plenty of reasons that that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon. I have not yet met a magistrate would not find that probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say. There's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, they told the magistrate about, that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video.
13 minutes is a long time to not know where that vehicle was and still act like you know where that vehicle went. That's a long time.
And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked, there's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known. That's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence. When there are other things in the affidavit that were affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe it,
Well, I'm just not sure why it matters.
See, blood, not touch DNA. And I mean, people were saying this in the chat earlier, and they're saying it now. She's not really honing in on the fact that this was like touch DNA. She's not. And it matters. Holy shit, it matters. Touch DNA is literally the court jester. This is how I've always described it. It is the court jester of DNA when it comes to the importance and the hierarchy of DNA. Blood, yo, that is like king. Shoot, that's the queen, okay? Because let's just be honest, the queen is the one who's really ruling shit, okay? Blood DNA is queen. This touch DNA, boo-boo, that's nothing. If I'd have went to the store today, I'd have came home with like 12 different people's DNA on me just for me going down the damn cereal aisle and then going to the checkout and swiping my card and touching the screen and all the things you do whenever you're in public. So how are you going to sit here and just act like this blood DNA is nothing? And she definitely should have been mentioning the fact that this was touch DNA, especially whenever she's trying to compare what was on that knife sheath to the blood.
Matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway, because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
Some earlier event in the house. Interesting way to put that, I guess.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence.
Okay. Now this is where I'm trying to figure out. I need to know if this is the same freaking glove that Chris McDonough with the interview room found. Because when I went back and looked back at where it was and looked at the pictures and the little pieces of video or whatever that were on his channel, and then I went and I looked up what electrician gloves look like because of the stuff that was written in 4chan. By the way, this was like planned out, all right? It looks like the same glove that was on the ground. But is this the same glove that was found outside that Chris McDonough found, or is this a second glove that was found outside? I don't know. And I can't take fake Detective Mallory serious with his answer. So I'm going to have to ignore that because, I mean, you haven't done anything wrong in here, but you're still faking being the detective, so I can't take your answer seriously. So I don't remember. Second glove. I mean, possible. And don't take it personal either, fake Detective Mallory, because I say the same thing whenever fake Papa Rogers comes in here. So I don't know. But we only had 3 unknown male DNA the first time around, which would have been C. Now we have a D. That means there's 4. That means there's 4. 4 unknown male DNA in a house where 4 people were killed. One of them's blood, no name. It doesn't make sense. It doesn't make sense.
She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car, and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
Okay, so that's the full amount of time that they're giving us is 13 minutes. Okay, so they have TikTok with Xana at 4:12. And they have the ending time of the crime being at 4:25, which is again 5 minutes after the car apparently leaves the neighborhood. So it is 5 minutes. I mean, 13 minutes. 2 different gloves, 2 different dates. Very possible. Yes. The frat theory was 19 minutes, including getting there and coming back, which is completely doable if the crime itself took 13 minutes.
The fact is, DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Applying the Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts.
Again, if the truth about his cell phone data and everything else would have been truthfully written down correctly and not fabricated and changed up to fit a narrative, no magistrate would have signed that because they would have known that touch DNA don't mean a damn thing if your location data tells me that you are somewhere the frick else at the time of the crime. No, a magistrate that had the true information in front of them would have looked at this and said, this touch DNA is all you have. And everything else says that he's not there. Everything else from his phone data and everything about everything that has to do with where his car was on camera or where it wasn't on camera and his cell phone location and everything else says that he wasn't there. And all you've got is this touch DNA. I don't see a judge that actually knows their way around anything. How they wouldn't be like, no, you've got to bring me more than this. I'll sign it after you give me more. I get you got touch DNA on the knife sheath, but until you bring me something that goes along with this, there's no way. There's no way that I'm going to sign this. That's what a real judge should have done.
As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable cause as Mr. Kohberger if his DNA is found on a knife she found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than unknown male B that we know of for sure, and unknown male D outside. There is a lot of context there. And all of a sudden, this one thing, the question of how is that there? Is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true.
Okay, so again, she's saying that what Dylan is claiming about a person up and down the stairs can't be true. But how do we really know that? Like, just because somebody might have been attacked in the bed doesn't mean that maybe they didn't run up and down the stairs first. See why this is confusing? Thank you, Mikey. I'm really glad that we're going back over this because there's a couple things that I misheard earlier, and there's a couple things that I wasn't able to catch. So I'm really, really glad that we're going back over this. And another gifted membership. That's awesome. Thank you. Thank you so much. I don't even know how much longer we have of this. It's 7 hours and 8 minutes. And oh boy. Okay. We got another hour. And you know I'm going to talk.
One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out.
I will also say something else that I was told by Turkey Face is that apparently, Dylan and Bethany were really at the memorial. And whenever Steve asked if he could speak to the girls, Bethany jetted, didn't want nothing to do with the conversation. And whenever he asked Dylan if she had heard anything, if she knew anything, if there was anything he could say to her, she said that she was asleep, didn't hear nothing. But that wasn't the case ever because Ethan's family said straight out from the gate that Dylan heard stuff. So why are you lying? Her story has changed all over. And like, I get being like so intoxicated that maybe you think that you're dreaming and it's not real, but was that what she was saying from the very beginning? Or did she try to act like something was concrete and then it went back? I just know that that's what I was told. And that's really freaking shady, especially considering the fact that both of them were like refusing to come back over state line. And if they really, 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 really thought that Bryan was the guy, what you scared for?
You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there.
I'm not quite sure, Bucks. Thank you for the $1.99, but I don't know. I mean, look at Delphi. Delphi literally has unknown male DNA under the freaking fingernails of one of these little bitty girls that fought for their freaking lives. And there's male liquid, okay, on one of their thighs that was not tested either, not even against Richard Allen. I don't have any faith. I mean, y'all that have been here for a while, you know my story. Y'all know a lot of my stories about why I have no faith in any of these systems, which is why I have a $60,000 degree that sits there and I'm not working in the criminal forensic lab like I'm supposed to be with what my degree tells me I should be doing because I have no trust in any of this. And I'm not about to have my morals and ethics tested because somebody's going to want me to not be truthful about what the hell I'm seeing in an investigation. Like apparently everybody here was just okay being wrong, putting wrong dates, wrong times, lying. So I don't know. But I know that with what we've seen in Delphi, I don't really have a lot of faith in a lot of stuff. But I know that they have already made it very, 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 very clear. And the state has stood up and stated this themselves. There's no social media. He was not stalking. There's no connections. The DNA is the single thing. The single thing. And they can't even explain it. Or give proof about how they even got to the answer. All I know is this. When I was in school, if we didn't show our work, you failed. It's just so stupid.
This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know.
I'm going to address this now because this is like not stopping. It's almost like scamming the entire chat. She does not state that this is whenever it was identified to be Bryan Kohberger's car. It is in this footage that the FBI agent finally, I guess, gave the year. But it's not saying that this is where they identified that it was Bryan's car. That's not true. And again, I could be wrong. But I would have like had a whole like, holy crap, what did she just say? If that was the case, and that's not, nobody freaked out. So I don't think that's accurate whatsoever.
About the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection.
There it is again. Social media. No connection. I had somebody in my chat swearing up and down that he had proof in his memory, I guess, that Bryan Kohberger had gone in and liked some stuff about Maddie on Facebook, but he didn't have any screenshots. And he tried to act like he like had all this proof and stuff. Like I should just believe him. Like he's, like, trust me, bro. But he had like no proof of nothing. And he was like, you're going to see it's going to come out. Really? Because every freaking thing they've said in court is the opposite, broski, that there's no connection. There's no social media. There's no cell phone, nothing. Nothing. The Goncalveses themselves even said it wasn't until after Bryan's name was public that they looked up all this stuff, that there was nothing about Bryan Kohberger. We also know that there's a crap ton of creators, Melissa Jade being one of the most ones that I know of, that took screenshots of all of the social media of everyone. And there was nothing about Bryan Kohberger in any of it until after Bryan Kohberger's name was given to the public. All those accounts were fake. And it doesn't matter that they had multiple followers or whatever. People can literally have accounts that change names constantly, and it's going to keep the exact same amount of followers. Just because the name changes doesn't mean anything. There's no connection. There's no connection anywhere.
The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this, but they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car.
Okay, so this is like a mute point, and I don't even understand why they're thinking that this is even going to matter. The PCA was written before anything of Bryan's was searched. So the magistrate would have not had any information on there being no DNA in his vehicle or his apartment or his parents' house or anything like that at the time that the PCA for his arrest was being written. I honestly don't have any clue why they're even talking about that. Like that's even a possibility, because that would not be a thing literally at all. And the fact that both of them are both not like connectively thinking about that, like, oh yeah, like how could the magistrate who signed the arrest warrant even know that? Because they would have had to have proven that there was no DNA in his car before that, and they didn't know that at the time that they were arresting him. They didn't even have possession of the vehicle until they busted into his parents' house to arrest him in the first place. So this is a mute, make no sense argument. I don't know why they both haven't realized that. That doesn't even make sense. It's in the wrong order of how this would work.
Or et cetera. Right.
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions. Yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
There's understanding complete.
Yeah. Thank you for that. I wasn't following the question the court was asking. I think the other thing I think I covered all on my proper, Your Honor. Thank you. Sorry.
I think now, Mr. Nye, were you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of them.
All right, go ahead.
Get ready. She makes the dumbest faces, and then she has no idea how to answer very, 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 very important questions. Just watch. Just watch.
I'm going to attempt to. Good afternoon, Your Honor. As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false.
So you're going to sit here and try to tell me that it's not deliberate, that you got a 7-minute gap in between when the phone actually goes off network and whenever you're claiming it goes off network? You're telling me that y'all are just too stupid to know that you wrote the wrong time, therefore it wasn't deliberate? Or that y'all are just too stupid to know that it's not accurate to put that he turned a certain way 2 minutes before he actually did, because you're just too stupid to know that you're wrong? You're too stupid to know that you're doing it deliberately? That's what they're trying to say. That it would have to be done without deliberation, without being done on purpose. You're trying to tell me that y'all are all too dumb to know what you're doing, therefore it wasn't deliberate. No. All fired. Fired.
That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence, or Scrivener's errors, or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim. And
This is all I need. This is all I need. What you mean failed? You got a 2-minute gap and then a 7-minute gap, 13 minutes in between the gaps of your car videos, nothing that makes any sense. What the hell do you mean he's failed? We wouldn't be here if he was failing his argument. He would have no argument. We wouldn't be here. He wouldn't be here.
they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation.
That's not true. Payne's PCA is, I believe, like 18 pages. I'm gonna pull it up right now. Because that's not true. Blaker's PCA was used for almost everything until it became time for the PCA to become public after Bryan got sent back to Idaho. Okay, see? This is Brett Payne's. 18 pages. Okay, 18 pages. 18 pages. I'll put y'all back over here. Now I'll go and open the drop where we have Blaker's. And I'm not really quite sure how many pages altogether. Here it is right here. I done lost my, it opened up to the spot that I was last recording my comparison, but I'm going to show y'all where it starts. Here it is right here. This is Dustin Blaker's. This one right here is the one that was given to the public as soon as they said they were going to release it publicly after Bryan got extradited and actually showed up in Idaho. Blaker's is hella longer. Okay, let me see. It's definitely hella longer. And it was Blaker's that was put with the information that we saw for Don Daniels for doing the apartment search, the office search, and I'm pretty positive it was the one that was sent to Pennsylvania. And for the most part, that's why I'm doing the comparison. For the most part, it's the same. And then we get to a certain portion, and this one is like just way longer. See, we're at 14, 15, 16, 17, 18, 19, 20, 21, 22, 23. It's not showing. I've been doing this whole thing without showing y'all. Okay, now we're at 24, 25, 26. Keep on going. This is Blaker's. It is 10 more pages than Payne's. 10 more pages. That's why I'm trying to go through them and see what are the differences and why are they 10 pages different. That's wild to me that they're 10 pages different. I don't remember it being anything like spectacular from going over it the first time, but it's still 10 pages different. Payne's is not the one that was used for stuff. It was Blaker's. That's why I don't understand why Payne's is the one that we were given, because it's not the one that was used. It was not.
You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then...
Great question. Perfect question. Where the hell is he? I don't think we're going to hear anything from him until trial. I don't think we're going to hear from Blaker until trial.
Put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
What do I do if the affidavit is attached to Detective A's submission? Is it Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
Well,
How does that affect
The Frank's analysis as it relates to the affidavit submitted by Detective A.
I would say that Detective A would have to have reason to know.
So it's obvious by who he's pointing at, who he's saying Detective A is. But again, Blakers says that it's Exhibit A, but so does Payne's. And they can't both be Exhibit A if they're supposed to be being attached to the exact same thing. It would have to be differently labeled, I think. Why are they not talking about Blakers? Wow, look at Jennings' face, how this like paused right here. That's a wild look. Like I can't zoom in, but that's wild.
That was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that.
She signed off on so many things. Her name is on a bunch of stuff from the very beginning of this arrest. That's why she's trying to protect this, because she knows that she screwed up a lot personally. Oh, thank you, Mikey. Thank you for the $5. What does that say? She missed the opportunity to pound home the fact that the DNA type matters and that it was on a movable object. The blood on a railing is real. Right. That's what I said too. Like, I feel like, and a lot of people were talking about that when we were doing this live. And then people were also mentioning that like throughout this whole time that we've been doing this now. Why is she not mentioning the fact that it's touch DNA? Why is she not comparing what it actually is? Especially whenever they're talking about the blood to begin with, like when as soon as she mentioned it and mentioned how it's unknown male B, and then we have the unknown male D with the glove outside, and she's talking about the DNA and how it wasn't tested and all these things, she definitely should have been talking about how this was touch DNA. I don't know why she did not make that more of a point. I completely agree. The judge really never says it either. I don't recall the judge mentioning the fact that it's touch DNA either. It's like a mute point to this entire courtroom for some reason when it should be like the main point. I agree.
But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding cast. I consulted.
No. When it comes to the warrant and where they got the information from, there's no names. We kind of like knew that Balance was part of the case, but it wasn't in the beginning like this. He doesn't state like, and she's gonna give an example later. And I just remember thinking like, there's no names. It doesn't say anything about it being Nick Balance. It just says, yeah, he's talking to the feds. But we knew that because Payne literally told us that he would go across the building and talk to somebody about it. and then on the way back to his office, stop and get coffee and check and see if he has any memos in his little mailbox, and forget half the conversation basically before he sat down and like tried to regurgitate what he was told, because it was basically just like word of mouth telephone stuff. I thought Payne already gave it to us. So he can't like take that back now.
With FBI, SA, Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from.
You cannot sit there and say that it was clear where the information was coming from and then say it was definitely inferred where the information was coming from. Honey baby, it cannot be both. Either you maybe make it sound like it's going to be like that, or it really is clear and it really does say that. It cannot be both. She's just trying to cover her own butt at this point.
The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the cast work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the...
Does it make that clear? Let's see. If I can let's see, balance. Is it it's not gonna let me do it on this. I know for a fact, okay? I'm just gonna say that I know for a fact. Okay, let me just show you this. This is the 166-page drop that we got the Pullman information from. Isn't it balance like you spell it normally, right? That word is in this 166 pages once, and it's not in the PCA. As a matter of fact, like I just said, there's no names in this PCA when it comes to pretty much anybody that actually helped do any of this, except for the first responding officers and Blaker and Payne. There's no FBI person's name in this, not that I can remember reading. So how can she say that it's clear as day what it says? No, it's freaking not. It would have the person's name if it was clear as day. We wouldn't be having to play all these games. Y'all told us from the beginning that it was like Othram that did the work, and then we found out that the feds came in and told Othram that you can't do anything, and now you're trying to cover up the fact that Othram didn't find nothing and trying to act like the FBI actually know what they're doing whenever there ain't no way. Ain't no way. So it's not clear. There's no names in here. The defendant is being honest about what is happening here. You are not being clear about anything.
The entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458.
Found it. Okay, so this is exactly where she's talking about. This is the CSLI stuff. I don't see Balance's name in this. Do y'all see it? I don't want to sit here and read this whole damn paragraph, but she's sitting here trying to say that it has all of Balance's requirements and stuff in here. But this doesn't have his name. This just says, after receiving this information, MPD consulted with an FBI special agent that is certified as a member of the Cellular Analysis Survey Team, or CAST. Members of CAST are certified with the FBI to provide expert testimony in the field of historical CSLI and are required to pass extensive training that includes both written and practical examinations prior to being certified with CAST, as well as the completion of yearly certification requirements. Additionally, the FBI CAST special agent that I consulted with has over 15 years of federal law enforcement experience, which includes 6 years with the FBI. Okay, but you're not telling me who that is, bro. You're not telling me who that is. You're just telling me that somebody you talk to has that experience, but you're not giving me the name. You could be making that up out of your butt. There's nothing that proves who you talk to. It's not clear, Miss Jennings. It ain't clear at all. You full of it.
Phone. That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by balance. Investigators reviewed that and then made some determinations of the approximate locations where that.
And again, we just saw that there was a document that was signed in, I think it was like February. Was it February? By Nick Balance about stuff that was apparently done in this case, but his name is not in that document. And nothing was signed prior to Bryan's arrest either. The document that we saw signed by Balance is after.
That 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed.
I'm so sick of hearing the word opinion. Facts are not freaking opinions. Opinions are what we have whenever we're out here theorizing and speculating. That's a freaking opinion. Telling me that you have a 2-minute difference in between when the car actually turned and whenever the phone records are saying that the phone actually turned, and whenever there's a 7-minute gap in between whenever you're telling me that his phone went off network and whenever your discovery in your own evidence tells you that his phone went off network, that's not a freaking opinion. That's you literally fabricating information and not putting facts in your information. That is not an opinion. I cannot stand the fact that they say that the stuff that these expert witnesses put together or that these experts in these cases put together is a freaking opinion. How can it be an opinion if you're supposed to be working with concrete facts like times and dates? It's just as stupid as saying that the IGG was a tip, in my opinion.
We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is cool.
Did you just see that? Y'all pay attention to what Judge Hippler does the second that she mentions something about 3 towers. And remember that Ann Taylor said 2 towers earlier. So watch Judge's face. He goes to just watch him.
Paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead.
Estimated, by the way. Estimated.
That is just a reflection. The work was done by balance. Investigators reviewed that and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have 2 different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is cool.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Frank's motion.
What specifically?
That there are 3 towers.
I believe
Remember,
I referenced it in my
proper.
response.
Yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I'm been very clear to say, I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what isn't.
We can just move past the fact that I'm stupid. We just move past the fact that I don't know facts from my butt. We can just move past the fact that I'm wrong. No. And if you noticed, Elisa Massoth's smile has not left her face the whole time. The whole time.
In evidence, though, and based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents.
And 10 to 20 miles from the tower as well, and every address in between. So, next.
Still maintain that's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of two buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant.
Now, Anne never said a damn thing about that. Anne never said that. As far as I can recall from now going through this twice, Anne never said a word about Dylan seeing a photo of Bryan. Did I miss it? Because I heard this from Jennings the first time around, but I don't believe that Anne said a damn thing about this. So I don't know why she is out here saying anything about this photo situation, because Anne didn't say nothing. But she also talks about the grand jury subpoenas later on here in a minute, and Anne didn't mention that in court either. So I don't know why she's bringing up stuff, but I don't recall Anne saying anything about a photo. This is the state again telling us that there is even less credibility to their accusations because Miss I Saw Eyebrows didn't recognize Homeboy's eyebrows. Okay? Not even a little.
Well, it's clear from reading the probable cause affidavit that she's not going to recognize.
Oh, it's the second person I've seen ask that. Who's sitting next to Bryan? Logsden's over here in the blue. I hate that y'all can't see my mouse because I'm going around his old bald head too. Logsden is over here in the blue, constantly on his phone and on his laptop. And then there's Bryan looking like he's shrank half his size. Massoth is over here with a permagrin. And then it's Anne on the far end.
The defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place? Okay, so it's
No, he's got a great point there, because if Jennings is now stating that Dylan saw a photo of Bryan and didn't ID him, then what's the point of putting what Dylan said in the PCA if it's apparently not true? And it didn't lead to her actually later IDing Bryan. What's the point of Dylan's statements being in the PCA? He's not wrong.
part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description is material and relevant.
but not material and relevant enough to put out a face sketch. And I don't care that you didn't see his whole face or that you barely got a glimpse in the dark of, not really dark because we know those string lights were on and so was there like a bright sign and everything else. But in Delphi, they put out all kinds of sketches. They put out all kinds of sketches, including one that had a freaking thing over the mouth and didn't hardly see all the face. So what's the point of anything that Dylan said being in the PCA besides the fact that they needed filler? Because in the end, Dylan didn't recognize him. But what I want to know is, when was she shown a photo of him? Was it prior to the arrest so they could try to get some sort of face ID? Because it would literally only be for this. And if his eyebrows didn't look right, and I mean, we saw him whenever he was arrested, there was no clipping. You could tell there was no like fresh clipping or manscaping or anything of his eyebrow. That was like his natural look. So it's not like whenever he was arrested, it was noticeable that he was trying to like cover up his face in any way. And even then, whatever photo Dylan was shown, nope, that ain't them eyebrows. I want dates for that.
And that material and that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something.
PCA doesn't say a damn thing about his race. Let me make sure. Nope. Oh, wait. Hold on. I might have been wrong. Nope. Open the door. Heard crying. Clad in black. Mask. Covered the mouth and nose. Walking towards her. 5'10" or taller. Male. Not very muscular, but athletically built with bushy eyebrows. Nothing about race. And it does state right here that Dylan did not recognize the male in like the statement of her seeing the person walk across her door. So if she didn't recognize the person then and then didn't recognize the eyebrows later whenever it came to looking at Bryan's face, there's no match there. Nothing from Dylan's statement should have been in there except for the fact. And see, I really want to know, like, did she even say anything about eyebrows? Because at this point, they're saying that her saying that somebody was running up and down the stairs is a false statement. While also saying that the stuff in the PCA is wrong. That's why I got to go back into that part because I'm really confused about that portion right there. That's going to have to be like a little separate video by itself. That's a lot to try to unravel. But I wonder if the eyebrow thing was like even actually talked about. Like, was that even something she really said?
That she recognized. The person was a slim, skinny, lean build. And the person.
See, that threw me all the way off whenever she said that because the slim, skinny, no. Slim, skinny is like my ex-husband. Bryan Kohberger, whenever he was arrested, that boy is over 6 feet tall and he's pretty big. Pretty big. Bigger than I thought. Bigger than I thought whenever we first like saw him. But whenever we see him in his red outfit getting on and off the plane and also being like taken through the courthouse by people that are already like hella big, the cops, Bryan is no skinny slim at all.
Person was taller than she is around 5'8". That's what's important. It was that general.
See, she didn't say taller than me. All we had in the PCA was 5'10" or taller. We don't have nothing about 5'8", but I guess she's just stating however tall Dylan is.
Description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when the timeline matched the vehicle.
Why did he just have to tell her that? Like, he just made Dylan's statements irrelevant, but then also made them relevant by saying, but wouldn't it also establish timeline? Why is he helping the state prove their fight? He should have just kept that to himself. That's them to prove that timeline, not for the judge to help them prove the damn timeline. I'm watching you, Hippler.
Surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period. And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit, you can take all of it out and the magistrate would still have probable cause. The second issue defendant, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those
No. If someone that you're claiming in the PCA is a witness to somebody walking past their door in the middle of a quadruple homicide, Mrs. Ma'am, it's all extremely relevant to know that the same freaking person thinks it also could have been a dream and that it might not have been real. It doesn't matter that the event actually took place. The very specific details that you're trusting this person to tell you so you can use it against somebody. It matters if she thinks it's real or not. What the hell do you mean? It literally goes into her mentality and what she actually thinks about what happened. I don't like her. Why does she have a job? I don't understand.
statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne.
No, actually, the specialist said 11 to 13. It wasn't until y'all had Bryan Kohberger's information that you went back to the specialist and he was like, could be. That's how we've been told very recently that's how that went. That they really wanted it to be the 11 through the 13, but then was basically like, maybe, but I'm still leaning on the 11 to 13. There's literally nothing concrete proven that is what the actual opinion of email, however you say his freaking name, that's actually what it was, and that he actually was like, no, it is definitely this new year. It has nothing to do with the 11 through 13 anymore, and it has nothing to do with stopping at 13 anymore. I am adamant now that we can go further. No. That's not how this happened. That's not how this happened at all.
Reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene.
Okay. Here's this map. This is what I was showing you guys earlier in the other live that we were doing. So here's King Road right here. Well, where it was, because they've already updated everything where the house is gone. Okay. This over here is 1125 Ridge Road. And it is this right here. It is this right here. Now, I didn't look to see if there were cameras anywhere on this one. I mean, just looking at this side, it's not like a house. It's also apparently not like a frat house either. It's like a condo, like apartment condo. I'm not really quite sure if it shows that there's cameras here. Oh, this is October of 2021. So yeah, it would be too old, I guess, to matter. Oh, that might be one. Oh, that might be a vent. Yeah, it's a little bit too old to even like really be able to tell if this was accurate enough when it comes to what could have been on the house. But this is it. This is it right here. Now, I don't know which way does it show in that it shows up. Like, which way is the front direction of it? This way. So I don't know because the map doesn't really give anything for what they're describing prior to the event. Really, in a way like the car really went, at least nothing that's clear cut, right? But they're claiming that it passed by here just like a couple of minutes before it ended up going into the neighborhood at 4:04 in the morning. Okay, well, I'm not really quite sure. That would almost be as if it would have to have come like this way to come down louder because we know that the car came, well, they're claiming a car came down Steiner, and then came this way. So it wouldn't have been able to have been in front. It would have had to have been this way. Maybe it caught it like this way, I guess. Because if she's claiming that it's on the way there, unless they took this ginormous ass loop-de-loop around Walinta to then get into the area, it would have had to have gone this way and would have been caught on camera in this intersection. That's what I'm getting from that. But again, unlike what that person in here was saying earlier, they're not claiming whatsoever that that's whenever they could tell that it was Bryan Kohberger's car. They're just claiming that at that point, they could clearly tell that it was a Hyundai Elantra, not that it had a damn thing to do with Bryan, because they've already made it very, very clear that there is no footage whatsoever where you can actually validate for sure that it is Bryan Kohberger's car. They cannot actually see if there's a front license plate for real or not because of how crappy a bunch of this footage is. And there's nothing at all, regardless of if it's security footage or traffic cams or anything else that they looked at, which, by the way, for those of you who don't remember, a lot of the stuff that Payne told us that they looked at was not in the nighttime hours. A lot of it was during the daytime. So it wasn't even like the right times that a lot of this stuff is being looked at. That's important too. That is important too. So again, it's not claiming that that was Bryan Kohberger's car at this Ridge Road address. It just says that it's clear enough to where this is where the FBI agent, I guess, would have decided, hey, this is really a Hyundai Elantra now that I'm looking at something more clear, is how I am taking that.
Which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene, they say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court.
So she's admitting that the PCA is correct in claiming that there's no true path one way and no cameras that show a true path one way. There's nothing the other way either. But because there's nothing one way, even though there's nothing that other way, it has to be that other way because there's no footage either way. So Jennings literally is admitting that wherever this would have ended up going, that the car should have been showing up in other spots along the route, and it's not. So she just admitted that. Is how it sounds to me, that she just admitted that.
Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response, that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter at the end of the day.
But there were other cameras. There's other cameras along that route, not just the one. So if this exact same vehicle is not on any other cameras going towards the area, and it doesn't match the one that's doing all the 3-point turns and whatnot, that matters if they're trying to use it all together. Yeah, this is just where it was clear enough to be able to tell it wasn't Elantra. And they didn't look, all I know is this: if they would have admitted in this that that was actually Bryan Kohberger's car, my entire chat would have blown the hell up earlier today, and that didn't happen. So I'm just saying.
The defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion. And they haven't made a substantial or sufficient proffer for you to do that. Next, the briefing addresses the IGG issue. And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that I don't know that you needed to. I don't know that.
No, there's nothing in there that gives any sort of, this is the street where we saw the car do this, and this is, no, it's only the stuff going on in King Road and turns and twists based off of GPS stuff that's wrong. And for her to sit there and say, oh, I don't think we have to put in there like where it was caught on camera. What do you mean? There's like a couple of things, but none of them string together correctly. There's like gaps of time. Why would you not need to? Sloppy as shit.
That all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No, nor did we need to.
Nor did we need to. Yes, you did. Because you got nothing. You got nothing. There's a reason why he asked you that, Miss Ma'am, because you did need to. And your information is lacking. Lazy.
really, the IGG has been discussed extensively. I think the only real Frank's issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for Frank's hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IGG and the use of IGG is only inculpatory. And
It's the only thing that's inculpatory. The only thing. How the hell are you going to sit here and have your own people that are helping you in this investigation, Don Daniels, ask for the magistrate court who's signing the warrants for Bryan Kohberger's apartment to ignore the IGG information that you so blatantly relay to them, but then act like it's not a problem? The IGG is all you have. And you put it in there because you knew that damn well everything else was a bunch of lying fluff with the wrong times, with the wrong information. That's why it's the only thing inculpatory that you have. And you refuse to show the work. It's the only inculpatory thing you have. The only thing.
and the non-reliance on the IGG information does not diminish probable cause. And the IGG information was confirmed through the STR testing. I can't wrap my head around any argument that IGG and STR testing would be exculpatory.
Because if it's the only thing that you have and you obtained it illegally and there's literally nothing that puts him at the scene, that's why. Like, I can't believe this person's actually a lawyer. Like, I get that she's working for the state and she's trying to, like, make a point. What she's failing, she has no proof of anything. None. Literally nothing.
Defendant makes kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones, at the end of the day, this is the proffer is their opinion of the evidence.
And this is what I said earlier. Honey, the PCA is the same thing just for you. The PCA is the exact same thing just on y'all's end, except when it comes to the defense, they're coming out and they're giving us the information how it actually reads with the timestamps that's actually in the evidence, not the bullshit that y'all put in the PCA to fit a narrative. Therein lies the difference here.
That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing.
You know who she reminds me of? Or like, not really a person. I guess you could say it's a type of person. The way that she comes in here and her like facial expressions and the way that she's like moving around, she reminds me of like that high school quarterback who never ever does anything else better with their life but be that high school quarterback that sits there and tries to talk to you about how awesome their life is, but they're full of shit and they suck. That's what she reminds me of. That's what she reminds me of.
Defendant next, the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendant's opinions about where the shoe print should have been located and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Franks hearing. Again, our case doesn't hinge on the identification of the shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information.
The shoe print matters because it's just one. It's just one. It's just one. And if you've walked through biologics, you're going to have a very saturated first step. And then it's going to decrease in saturation as you walk. And there should be, I mean, I guess you could walk through biologics with just one foot and miss it with the other foot, but there would be a progression in a decline in the amount of saturation as this footprint is walking, like as the foot's walking. There's not that. There's just one. And the more that I've thought about it, I'm kind of like, especially since she hasn't said it yet, but they're going to mention like exactly where this was found. And it's not really like it's like in the hallway in front of Dylan's door. It's more like it's smack dab in like where the door would meet the floor in the door frame, like right inside like the threshold line is where it was. And again, you can't do that with one freaking foot. If you're walking through stuff, there's going to be multiple steps and they're going to fade as they go. And this is apparently just one. So either they really, really, really just missed in their cleanup job, or somebody was maybe carrying some shoes that had biologics on them, and maybe the shoe fell out of their hands and landed down, and it was picked up. That's the only other thing that I can think of that would make sense for there just being one. That's the only other thing I could think of.
I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Just, before you get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of travel?
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her.
This is where Jennings loses her shit. Okay. This is where she has no idea how to answer this question. And you see how she like nervous laughs and her eyes get big, like she's on some sort of stimulant and she gets all crazy. She's about to put on a real big nothing. Just watch.
Her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's-
Detective Payne? Or by
Correct,
the
with
cast member?
information that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information.
That is not what Ann Taylor is saying. They're saying, Bryan's team is stating that the information that the local agency got from CAST was put incorrectly in the PCA. That in the information that they got from CAST we'll just use what we already have, that the phone actually went off network at 2:54 in the morning, but the PCA says that it went off network at 2:47 in the morning, and that's not what the cast says. So no, she's wrong again, just like the other idiot was wrong earlier whenever he tried to say that they're trying to claim that this is not Bryan Kohberger's DNA, and the defense team has never not once freaking said that ever. Ever. They want to know how it got there. They never said it wasn't his. They don't even know how to freaking argue their own shit. It's ridiculous. But she can't say any of this. Just like he couldn't say any of this. That's not what's being said here. They're not saying that the cast report was false information. They're saying that it was interpreted and the data on that cast was transferred incorrectly to the PCA by the local agency that wrote it, meaning Moscow. Moscow took the cast information and did not accurately input it into the PCA. They lied about the information that they got. That's what's being said here.
Apparently there's a difference in the handoffs of 7 minutes. At the end of the day, okay,
You know what? We probably should have done a drinking game because damn, how many times is she going to say that?
no, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's
If
material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off.
No, they cannot say that. They cannot say that it was turned off because they have no proof. They have not told us at all from the forensic download of Bryan Kohberger's phone if it was actually powered down or if it actually just went off network. And if you go based off of the fact that anybody and everybody that has been in that area and gone the other direction from Pullman that doesn't go to Moscow, that they lose service. And that includes correspondents from mainstream media that go that direction, have driven this alibi route, and have no service and cannot report back to their main people at the network until they get back to Pullman because they've got no service. Quit lying. Quit lying.
Isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not.
No, that's exactly what you have to prove. That's exactly what you have to prove. And this is what also didn't make any sense, okay? Because the original timeline was between 3 and 4. And then it moved after they arrested Bryan to between 4 and 4:25. But he's leaving Pullman, according to them, he's leaving Pullman on the cameras at like 2:42 is whenever he's making that turn that pulls that way towards Moscow, according to them, according to what they're claiming. According to what they're claiming, there's a turn at 2:42. It would take him the time of the original timeline to get to Moscow if he was actually the guy. So why wouldn't they have just left that in there? How it was. because them moving the timeline makes this even less believable because they cannot give us a complete connected string of where this car actually went the entire way with no interruptions, and they still have not been able to prove beyond a reasonable doubt with all the proof that it's the exact same car they're following. If there's already spaces where they have the wrong car and they've already come out in court and stated, well, this one's not the right car and this one's not the right car and this one's not the right car, how many of the other ones aren't the right car? How many? Because according to what Ann Taylor said, the car that does the 3-point turns and all the crazy stuff inside the actual area, it's only seen on one camera. That exact same car is not seen on any other camera that they have in evidence, just the one. That means that that car never left the neighborhood? Is that what that means? Or it went a direction where there was no camera and they picked up a car that looks similar to it, but it's not it because the important car is only on one camera? I don't know how we got here. I really just don't know how we got here.
It's a leap for me. Does that answer?
Well, it's your answer, so.
It's not the answer he probably feels like he should have gotten, but it's her answer. That's how I got that.
Let's say it was. Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included.
It was.
It wasn't, but let's say it was.
Oh, it was though.
Well, the magistrate still had enough information before her to grant probable cause for the arrest.
That's only because y'all lied. That's only because you lied. If the magistrate would have been given the real information given to you by the FBI, as little as it might have been, you've already proven that your timestamps are apparently off. And if the Goncalveses were so adamant about the girls' timelines not being close enough, but being accurate, then why are they not throwing a fit about this? I just don't understand it. I don't understand it.
So we still don't get to a Frank's hearing, even if you want to make that leap. I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Frank's hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights.
Notice that she couldn't even say that without taking a giant gulp. You notice? You notice? And it does matter because this federal grand jury happened and they didn't tell us anything. It wasn't until May that they put the Idaho state grand jury together. And then what were we told? Wasn't it the state one that we were told that there was like 6 people that needed more information? I'm pretty sure that that's the one. So yes, it matters because if you brought all of the feds information in front of a grand jury and it failed, so then you had to do a state one in order to keep your man behind bars. Yeah, it matters. Because what did you lie about? What did you give false information about? Hey, Harsh. Yeah, about the car. See, that's why I don't feel like they changed it to where it could have possibly been to that year until after they had his name. Yeah, until they actually had it. And that's why it made no sense to me that some people were trying to act as if that 1129 tip mattered because they would have had that information way back in the day and they didn't do anything about it until after the IGG. So no, the whole thing is like the most ridiculous case of reverse engineering I've ever seen.
They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Frank's is not the proper avenue.
Then what would it be, Jennings? What else would it be? Because they've tried all kinds of other ways and you won't do it. And the court won't do it. And for some reason, y'all don't want to show anything that the feds did. Nothing. When it comes to anything, when it comes to the cell phone stuff, it's apparently the wrong dates, the wrong times. When it comes to the IGG work, everything's been deleted. Why are you not willing to show, or is it the feds are not willing to show a single stitch of what they've done? And we're still sitting here. It doesn't make sense.
We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that.
I'll agree with that because they didn't do an investigation. That's basically them admitting that they didn't do shit. Because they wrote an arrest affidavit based off of literally nothing. And at the time that it was being written, stuff was being conducted, they didn't know then that there was no connection. They didn't know that there was no connection in social media because whenever they went through the victim's information, nothing about Bryan popped up anywhere. Because they didn't know anything about Bryan until the IGG. So of course not. You just admitted to us what we've already known this entire time. That you did nothing in way of investigating literally anything. And you knew nothing of Bryan at all until somebody else did a job for you. Not the job, did a job for you.
Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you that the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have.
How the hell do we have the lead prosecutor stand up in court and claim that so many things are false? And that's fine. But the defendant comes out and tries to say the exact same things are false, and suddenly that's just impossible. He's wrong. Y'all have already admitted that y'all got nothing here.
Found probable cause. I ask that you deny their motion for a Frank's hearing. Thank you.
Well, briefly.
I'll try.
I'll try to do my part to make you so that you can and avoid asking questions unless I'm truly stumped.
Before I get started on what I want to tell you, I'm in response to what the state said and then my summary. I'm curious about the new police report that was talked about. I didn't see it in the submission given to Your Honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Frank's hearing.
No, I don't know what the hell she's talking about. And that threw me when she said that, because in listening to all of this, I didn't hear anything about a new police report. So I'm wondering if maybe this was something that was discussed during the closed session and it's getting brought up now. But we do have something in the case summary, and I don't think it came public yet, but it's something about like a new file document or something like that. Let me pull it up and see the wording on it. It's up here. Newly filed record. I'm wondering if this newly filed record that has now been redacted and ready to be sealed, I wonder if that's this new police report. And what is it? I'm curious about that one.
Well, that's good because it occurred after my Frank's briefing came. So I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas. And yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used the returns from the grand jury subpoenas. It used the return from the grand jury subpoena to obtain information, and we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us, and that's kind of gotten to be
Amazon.
Sorry?
Is that Amazon?
It is Amazon, Your Honor, and the return on the search warrant says that they already produced them pursuant to something else, and the affidavit says we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem.
Yeah, this entire case has literally just been trust me, bro. All of it, the whole way through, everything.
So I think we should have a Frank's hearing to explore what that really is about, if for
What's
nothing
the
else.
omission that, or the misstatement that you're, as it relates to the Amazon warrant?
The omission is the FBI used the grand jury system and obtained this information outside of the warrant process. But for some reason, we need to come and get a warrant because nobody gets to. I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
I mean, I guess from a Frank's perspective, though, the question is there a material intentional misstatement or a reckless misstatement?
From Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
It disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to just go ahead.
Okay. I'll go backwards.
So here's the thing about that. As far as I can tell, there's nothing about Amazon in the PCA. Like, this isn't pulling up anything when it comes to Amazon, and everything else for this has popped up words whenever it has been there. This is the 166 page, because this is the one where we pulled up the cast info, right? So I'm just like showing you that the damn tool is working. There's nothing on here for Amazon. Now, I know we have search warrants for Amazon, but we have no anything when it comes to what was truth of anything when it comes to Amazon. As far as I can tell, they're like, it's like basically looking for the type of knife that it would be, but there's nothing to really prove anything as far as I can tell. So whenever Nancy Grace started talking about the Amazon warrants and the knife on Amazon and stuff, I'm like, I don't remember there being anything concrete saying that he actually did buy a knife on Amazon. I remember we did get some sort of list early on of, like, I think it was just like states where this very like specific serial number or whatever for this knife was actually sold, and like how many in that state had it. I can't find it anywhere. I might have it in a video. Maybe. I'll have to go back and see. But I don't remember there being anything concrete about Amazon and Bryan and actually having a knife that matched this and it being from him. And again, I could be wrong, but I don't remember anything concrete with that. But it's also not in the PCA. It's not in the PCA. So I don't know why they're talking about it for right here, because it doesn't look like it was used to arrest him at all. It's not in the PCA.
The 7 minutes that's not disclosed, that's intentional, but that's not given to the magistrate to make the decision. There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas. I want to talk only about a couple of other things. the credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially.
See? Just the one. It's right there in the doorway itself. There's nothing anywhere else in the house. It almost does feel as if somebody was carrying a shoe and dropped it, or it was missed in the cleanup. I don't know any other way that would have happened. I really just don't.
In context of the misstatements of the witness. I want to go through these. I won't read them in there.
And yes, I have to be up in 6 hours, a little bit less than 6 hours.
Entirety to the court. But Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And
how do you know that? How do you know that? And see, right now she didn't say up and then down. Right here, she just said down. But how do you know that? How do you know that one of the victims was not running up and down or however? How do you know that one of the victims was not running on the stairs, period, point blank at all, just because somebody was found in a bed? And the only person I know of that would have been found in a bed that would have been female, that would have been running up and down the stairs, would have been Maddie and or Kaylee. Because Xana was found on the damn floor. Man. How can you say that that's not true at all? She's going to have to explain that to me. Like, I understand they're saying that she was apparently inebriated, that she herself was saying that she was having memory problems with which honestly, guys. No, this, okay, yeah, let's backtrack, because I've seen somebody else ask me. This is a Zero Nic vape. I smoked menthol cigarettes, Marlboro menthol cigarettes for 20 years. I stopped smoking about 2 years ago. I smoked since I was 15. I quit whenever I turned around 35. It was easy when I left the idiot because I wasn't stressed out so much. Like, I was having to watch my back and stuff, whatever, but I didn't have, like, I wasn't having to deal with him in my face all the time. So it was really easy to quit smoking cigarettes. It took me using Elf bars, pretty freaking high nic Elf bars at first in order to stop smoking cigarettes. And then some crazy stuff happened with him, of course, after, because we know we had to deal with him after forever. And I started, like, I bought a pack of cigarettes because it was like an instinct, and I lit one, and it was the nastiest thing I ever tasted in my damn life, and I never bought another one since then. This is, the one I use now is Palix. The smoke shop down the street, buy this only for me. Because I asked them about Zero Nic ones, and they had the Elf Bar Zero Nics for a while, and then they were having issues getting those from the state they were ordering them from because of laws or whatever. And Palix is the one that they found for me next. They specifically told me they ordered these because I asked for these. Well, I asked for a good Zero Nic. They bought this one. These are great. These are awesome. And they're chargeable. It's a regular, you know, the C charger or whatever. And no nic. And I get all kind of different flavors. I love fruity stuff. I'm not into dessert flavors, and I don't want no menthol because I smoke menthol cigarettes. I can't do menthol. But yeah, Zero Nic. Really, I just get them now because it's more like the hand to mouth like fixation of doing that for 20 freaking years. And I just like flavors. Like, it's just tasty air. This one's Black Dragon Ice. So it's just sort of like a little bit refreshing. It doesn't have any mint to it. It's just refreshing, and it just tastes like dragon fruit and like blackberries. But yeah, I saw a couple of y'all asking, so I just asked. There you go.
And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definitely.
And see, that's the first time that we hear about the bathroom situation. And I know that like a bunch of people were really questioning, like, why are they talking about the bathroom in the PCAs? I don't understand. Huh? Who the hell is this clown? I don't even know who the hell you are. You are literally out of your mind. And for one, me and Melissa Jade are just fine. I don't even know why you're even mentioning her name in here. If you haven't like been paying attention, we're covering 2 completely different cases. She's over there on that stupid dude with the tattoos on his face. I'm covering this one. Why the hell you're trying to? And by the way, you had to be a subscriber for 10 minutes just to come in here and like run your dumb ass mouth. I don't even know what you're talking about. Plus, I don't have YouTube friends. Me and Melissa Jade are just, we text back and forth, and we have a great YouTube relationship. I don't know why you're even bringing up other people. Like, you got to be some kind of stupid. Like, kind of dumb. I'm not even going to block you. I'm going to let people just tear you apart. I'm just going to leave it here. Anyway, I don't understand why they're using so much of this to try to state that this statement isn't real just because Dylan was having issues with her memory. That doesn't necessarily mean that what she thought was happening wasn't happening. That's why I really need them to tell me that. I really need them to pay attention to the details there and explain to me how they can say that just because she was drinking and maybe has a little bit of memory issues, that wasn't a possibility that somebody wasn't running for their freaking life. Because you can't sit there and try to make me believe that, you know, first off, y'all don't even mention this shit, like ever, that anybody heard anybody running up and down those stairs. But then you also sit there and you say there was unknown male DNA found on the handrail of those same freaking stairs. That was never, no name. Like, I'm sorry, but I'm not going to even like try to like look past the possibility that that definitely could have been something that did happen.
Definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle is identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video.
The state's expert. So is that the state's expert or the FBI expert that's helping the state? Regardless, if they said themselves, I can't tell what this is. I can't tell what this is. I don't know what kind of car this is. There's no way that I can tell. And then more footage came along that expert was told was part of this investigation. It's not up to that expert to prove that that car is what the investigators are claiming that that car is. It's his job to just tell them the type of vehicle that it is. So that's even more that's not being double checked. It's not being peer reviewed correctly, I guess is the way that you can put it. It's not being verified. It's just like the way that Mallory told us that he was just sort of like putting files in a folder. There was no organization at all to any of the footage. None of it. It was just thrown in there. Man, there's just way too many things that go that way.
It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What do they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make positive ID on the car.
Where's that in?
That's the only one that the expert himself apparently is claiming. That's the only one that you can even tell the kind of car it is, much less be able to tell if it's the exact same car being followed on all the camera. That's pathetic. That's pathetic.
Record?
The 1125 Ridge Road. Well, it's in our discovery.
Or is it in the motion?
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you.
I cannot wait to see all of this stuff at trial.
Is it in the lines? It's in one of these. I believe it's on page 17 of the amended memorandum.
That's just the photograph,
Yes.
but not the information that ties that to the Ridge Road camera?
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court, that was the video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Well, but that's not the standard.
I understand that. I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today.
Yeah, where's that guy or girl, whoever the hell it was, that was in here saying that Ann Taylor was going to be the one to admit that that was Bryan Kohberger's car at 1125? Where you at, bro? Sup, RV, keep it rolling. Where you at? That's not what the hell was just said. What she said is that out of all the footage, the state in the emails between whoever and the experts, when they're sending the expert information, are saying, hey, we finally got a good one, and it happens to be 1125 Ridge Road. And all that meant is that they could finally tell what car was in that footage. Whatever in all the other footages and in all the other photos, you can't even make out the kind of car it is, much less tell if it matches the one from before or the one from after. So no, person who's no longer in here to be proven wrong after running your mouth forever. No, that's not what was said.
I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there, but nothing happened until the IGG happened behind the scenes and in a closet. That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation.
Oh, look, he did show up even though he's wrong. That's ridiculous. I've got something to say. Boom. She clearly said the car was identified. Did she say that it was identified as Bryan? No, she didn't. You got nothing to say, broski. You've been wrong this entire time. Like, did you not listen to no, not even me. I've got something to say. It doesn't matter what I said. Did he listen to anything that was actually said out of Ann Taylor's own freaking mouth? Because apparently not. You've been sitting here forever to be wrong. She did not say that they made a positive ID of it being Bryan's car. She said that was the only video that they had that proved what kind of car it actually was. And that doesn't mean that that exact same car was ever over on King Road. So you've been wrong this whole time. What were you in here for? To say boom for what? Drip drop junior? What do you mean? You wrong. You've been wrong this whole entire time. You done?
It's a complicated investigation, but you have law enforcement repeatedly meeting and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. And what these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made.
Facts were changed. Not just statements. Facts. Facts were changed.
To leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case.
This right here, this person right here is the prime example for why like humanity is doomed. Rewind it. That was what she said. No, bro, you done said already over here doing this that you done listened to this 3 times and you've been wrong about everything that was said. You go rewind it. Boy, put the captions on. Then come back and talk to me.
Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too, to leave just a little out here, to add a little more here and go get a warrant and then build everything that comes from that. And that's what happened here. Your Honor, we ask for a Franks hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't just pages that we made up. There's a lot going on here, and we need to have a hearing to fully explore this. Thank you.
All right, we will adjourn for today. I will take the Frank's motion.
Okay. Okay. It's been 5 hours. 5 freaking hours. That's a long time. My butt is numb and I need to pee. We've not moved in 5 hours. But I'm really glad that we went back over that because there was a lot of that I missed. This makes less sense to me. Actually, you know what? It's actually starting to make a lot more sense to me, but the reasoning behind it is still not making any sense to me. So we know that the feds themselves are like not wanting to hand anything over. For one reason or another, the feds themselves are refusing to hand certain things over. But then we also have, on the other hand, the state taking the information that they got from the feds and obviously putting it incorrectly to where it's off by minutes in a crime that only took minutes. So we have the feds not wanting to hand over more because whatever they've already given the state has screwed up in the way that they've interpreted it. The entire thing makes no sense. The one piece of evidence that they are claiming that they have doesn't even make sense. Othram, that's been solving things that go back like 80 years, couldn't find anything. And suddenly the feds double the sequence and suddenly they find something. And that's all that they have. And they can't even explain it because they broke their own rules to get it. How do you not test DNA found on the handrail of a stair that was smack dab in between two bedrooms where 4 people were killed? That doesn't make sense. And how have we gone this long and they still haven't even tried to test it against Bryan? It's the same thing in the Delphi case. Again, they have under fingernail DNA and stuff on one of the girls' thighs that does not freaking belong there, and they still haven't even tested it against their own suspect. That's just wild. Okay, it's 2 o'clock in the morning. I clock in at 8:30. So I normally get up at like 7:30, 7 o'clock, depending on what time I go to bed. And we have another session tomorrow. Hopefully we don't have 5 hours and 30 minutes of no sound. Because it was nice chatting with everybody, but damn. 5.5 hours of nothing. What a shithole of a case. I am going to go take a magnesium pill and go to bed. I will see you guys tomorrow morning. I'll put the link up in the morning whenever I get up for us to watch tomorrow's. And we will probably, I don't know if we're going to go through the whole thing if they end up going all day long. I'm just going to like take as many notes off to the side as I possibly can so we don't have to go through 8 hours of stuff to go back over stuff. Yeah, I think that's how we're going to do this. No, I can't do sick days. I just can't do it. I did this to myself. Yeah. Wow. Yeah, magnesium pill and try to wind my brain down. I will see you guys tomorrow. See y'all.